The petitioner is in custody for more than 7 years. He has been convicted under Section 302 and
Please give it. And we pardon your lordship. The matter related to sufficiency act, your lordship. Here and the auction procedure, we have paid all the money. In the meantime, one borrower has been died, opposite party. For substitution, we have filed an IE, your lordship.
My lord, petition have been a lot of long, and 13 to notice is issued to auction the house of the petitioner. Urgent urgent.
13 to notice, you can file your representation under 13(3)(a). Have you not? They must have given, so you have to
No,
file.
no, no.
Why have you not filed? Why have you filed the writ petition?
Then
Once you get the notice, they must have given you in that notice itself.
in that auction to sell the auction date fixed कर दीजिए.
Auction sale notice has been issued.
Yeah.
So like, go to somewhere else. ठीक है अपन को.
Tomorrow.
We'll see the day after tomorrow. Yes. One mention matter. One 2021 matter matter. We have challenged the DR80 order, DR80 Calcutta order. In this case, this matter was. Who are you? I am for the applicant, my lord. Petition. Means who auction? Borrower or auction? For the borrower. Borrower. You have lost your case here. DR80. Or to give it this. To content matter, my lord. Resolution. Yes.
This is readable in the year 20. We are the opposite parties. The implementation order had been stayed in this appeal. We are depriving to getting the promotion. This matter may be.
If this is an after notice matter, the CAT order has been challenged. It was supposed to be listed on 12th of September.
Phrase matter.
For orders, for admission. After notice.
It has not been listed earlier.
No, your lordship. By the last order, it was supposed to be listed in week commencing of 25th of August. After that, it was last listed on.
TRL appeal granted interim bail in 3 months for 3/8/25. To grant the interim bail, old mother is nobody is there in family.
Surrender. Yeah. After availing the interim bail period, have you surrendered?
Yes, sir.
You have filed a fresh bail application.
No, fresh not surrendered.
Not surrendered.
Not surrendered. When fresh matter not.
No, are you?
3 months given interim bail.
He is on interim bail now.
Yes.
For 3 months.
Yes.
You have not surrendered.
Yes.
You want extension of it?
Yes, sir.
Why have you not surrendered? Why have you not surrendered?
Sir, he is an old mother. Is nobody in their home there to family look after her.
So you will stay there for indefinitely. We have granted you for some consideration has been made. 3 months bail has been granted. Surrender will see your bona fide that you are surrendering at right time. If you flout the order, this ground, that ground, you just don't, then you cannot gain even the bail in future. Right? Comply the order, file a fresh bail application. Here. No. Just file another application. We do it.
Criminal appeal of the year 2020, IA for bail has been filed.
But I filed so many memos. No, it is not in district.
I mean, pardon for a sir. Page to I have already filed a memo for Udar. Filing memo for Udar of the
Item number
13.
So, who is there for Union of India?
Mr. Kashyap, I have solved a copy on the way and he has received the memo.
I've been served a copy.
Mr. Rautha and Council appealing for the petitioner files a application for withdrawal. Okay. The petition, Mr. Kashyap and Council, Central Government Council,
Senior Planning Council.
Senior Planning Council is present to confirm. Memo is taken on record. Petition is full. Yes.
Supplemental list. Item number 1.
You are challenging order of the Learned Single Judge.
Learned Single Judge.
Which is that order? Annexure?
Annexure 38, Your Lordship, page 439.
What was your petition?
Prayer that malus, I was removed from service malus after an appraisal committee malus. Challenging that removal of service malus, I had approached the Honorable Single Judge to quash the same malus, and the same was dismissed malus. Hence the present writ appeal.
You have prepared that date chart.
Date has been given malus. The Lordship may see the second bookmark. There is a list of dates. Second bookmark malus, the saved articles. Second from the list of date. Yes, Your Lordship. Just in the year, may I submit the facts?
Yes, yes. You want the assistance of the
No, I
petitioner
don't.
himself. You don't want his assistant.
I
Because he's present, I would have asked him to sit by your side.
Why don't you sit in the second row comfortably? And whenever your assistance is required, we'll call. Second row, you can sit.
So you come, let him sit here.
Here also.
Come.
No.
Bring your files. Bring your files.
Yes, Lord.
Be comfortable. Yes. Please take your seat. Take your seat. Yes.
Manoj, the present appellant joined as assistant professor in the School of Biotechnology in the year 2010. That is on 28/7/2010, Manoj.
Yes.
He was joined. And was offer letter is annexure 1, appointment letter is annexure 2. I'll come to the appointment letter later on. Thereafter, Manoj, after a few days, that is on 3/6/2011, there was an inquiry committee, and on the basis of that inquiry committee, Manoj, my probation period was not extended, and on the basis of which, Manoj, on 26/2011, that is annexure 6, I was terminated from service, Manoj.
So your first appointment was on a probation
basis, Manoj.
Period of
1 year, Manoj. Lordship, may kindly have a glance.
Then assessing your performance, etc.
It was there. Annexure 2, your Lordship may kindly see. That is page 77.
So the authorities were not satisfied with your performance.
That is later, Manoj. That will come on later. First, it was that in inquiry committee was there. I was removed from service. I challenged. There are two writ petitions.
Inquiry was conducted.
Inquiry was conducted that on the basis that I was not doing my duty.
During that probation period.
Doing my duty diligently. Yes. Hence, on the basis of which inquiry report was conducted, inquiry committee was conducted, and thereafter on 26/2011, I was terminated from service. Thereafter, I challenged in the writ petition number 17171 of 2011, and the Honorable Single Judge is pleased to pass an order on 29/9/2014, which is annexure 9, page 89, Your Worship.
Yes, what was held?
It was held that I was deemed to be confirmed in service, man. Your Lordship may kindly have a glance. Para 27.
You proceed first. Let us understand.
Let us
proceed. Then we'll.
It was that I was deemed in service.
Report to the annexure.
Lordship. Thereafter, my lords, I was deemed to be continued service, and I was and the KT University, opposite party 1 and 2, was directed to pay 60% back wages, not to 100%, because of the fact that I have not worked in that period, 2011 to 2014, as I have not actually worked, hence only 60% back wages. Thereafter, I rejoined. I applied. I gave the letter with the certified copy.
Yes.
I rejoined, and rejoined my lords there on 16/10/2014, my lords. That is annexure 13 regarding rejoining of appeal. Thereafter, certain conditions were imposed, my lords. I will come to that later. Thereafter, my lords, on 20/10/2014, my lords, they paid me the 60% back wages. Once again, in another order dated 3/11/2014, it was alleged by the university that I have not been going to the School of Biotechnology and not doing my duty. That is on 3/11/2014. I gave my detailed reply to that also, my lords, section 19, my lords. Thereafter, they also directed to give me further reply. Thereafter, my lords, again the office order was issued on 22/11/2014, that's Annex 27, terminating the appellant after an appraisal committee. Hence, I challenge that the same before the Honorable Single Judge on petition number 23250 of 2014, mostly on two planks of argument. One is that when the previous rate petition have given a clear and unambiguous order that I shall be deemed to be continuing service since 2011. Hence, I cannot be stated after rejoining to be a probationary person, my lords. That should be considered that I have become a permanent employee of that university, my lords. That plan was argument was there. Second, that, my lords, the appraisal committee, my lords, which was conducted, was done behind the back. No opportunity of hearing was given. Moreover, they say that I have not doing my duty as an assistant professor in biotechnology when they themselves have stated that they have not assigned any duty to me. Without any absence of duty entrusted to me, I cannot go and teach anyone else. Duty has to be assigned. On that ground, two of the grounds it was raised in the writ petition.
Now let us see the single judge reasoning.
Malice. Annexed to your lordship. Page 77.
Appointment.
No, we are not on that. It was
Come to the reasoning of the let me single judge.
single
Called
judge.
exactly. 36. Annexure 36.
Annexure 38, your lordship.
38. Okay. Let us see.
Lordships are hinting the earlier judgment or the
No,
present judgment?
The impugned judgment.
No, that is not. Sir, Olga page number.
Impugned judgment.
Annexure 38.
No, no,
38.
impugned judgment. Presently, that are impugned.
430 next page.
You said annexure 2. That's
No,
why.
next 38.
No,
I've come to-
38.
that is judgment dated 17/2017. Is it correct?
Yes, your lordship.
Let us see your prayer then. Prayer procedure with opinion. 17/2006. Right.
Yes, your lordship. 17/2017 and 38, your lordship.
Yeah.
And that, my lordship has formulated my points of arguments on para 8, your lordship, page 448, wherein all the points that I took, my lords, with regard to being a confirmed employee, as the order of this honorable single judge was passed earlier.
Come to para 26. 407.
Yes, your lordship.
Read it.
In the light above settled position of law, we find that ratio of the decision referred to and discussed as above. In the instance case, it is seen that on rejoining of the petition, he has been specifically appraised of the fact that he has to perform and discharge his duty for the residue period of probation being indicated therein satisfactorily. This was by the office order dated 16/10/2014. By further order dated 3/11/2014, the petitioner has been informed about his absence from duty and non-adherence to the standing orders in the matter and having nexus with the maintenance of general discipline in the institution. Though explanation to that effect has been sought for, no other action based on that has been taken. It is thus seen to have reminded at the stage of informing the petitioner to take care of those aspects and further act accordingly. The final order of termination that has been made on 22/11/2014 runs as under. That is, my lords, it is reported, page 472.
Read it. That's
The
very
period of probation of Dr. U.K. Samanta appointed as assistant professor in the school is due to end on 23/11/2014. The question of satisfactory completion of probation by Dr. U.K. Samanta has been assessed through an independent appraisal committee. The university decided not to continue employment of U.K. Samanta, assistant professor on probation in the School of Biotechnology, beyond the period of probation scheduled to end on 23/11/2014. As a result, his employment under the KIT University comes to an end with effect from the afternoon of 23/11/2014. Thereafter, the Honorable Single Judge has stated that the above order appears to have been passed in relation 2 and keeping confined to the satisfactory completion of service of the petitioner as provisional, which is said to have been assessed by the independent appraisal committee as ultimately also coming to be accepted by the opposite party number 1 without setting any different tone. There remains no such hint to the objectionable or blameworthy conduct. Undoubtedly, no inquiry at any given of time has been conducted. Specifically, with regard to the facts stated under Annexure 16 and 21, that is Office Order dated 3/11/14 and 15/11/2014, respectively. The narration in those office orders touching the duty of the petitioner said to having their foundation and fact as available on the record coming to be maintained in regular course. The tone and tenor of the lengthy response of the petitioner to the above office order being cumulatively viewed go to indicate that the petitioner who, instead of keeping the matter confined to the very subject, has rather stated such other matters, also in raising issues unrelated to those narration in the orders. The opposite party number 1, having sought for the explanation, has not further proceeded in those matters by initiating any proceeding and in causing any inquiry for recording any finding on those courts. So, there the ground for termination now is found to have been based on the performance of the petition during the period having no such punitive flavor in cause or consequence. Thus, the present case falls short of the test as laid down with the approval in Radhasham Gupta case supra. There remains no material to indicate the same is based on satisfactory of any such misconduct. The opposite party number 1 in any event has not adopted the course of holding an inquiry as and has also not proceeded to terminate by recording the ground from any other proceeding. Thus does not appear to be a case based on misconduct being attached to the petitioner having license with the termination. Merely because this order of termination and Annexure 25 has come out sometime after rejoining of the petition, being successful in the writ application filed by him, and by virtue of the order of this court, which in the fact and circumstances, an earlier finding is obvious and not avoidable in view of order of appointment stating for confirmation and regularization. No such inference can be drawn that the present order of termination is founded upon those allegations which rather have been left at the stage without further investigation. Touching the question of guilt or otherwise of the petitioner, further, this order of termination is found to have been recorded no such injurious reason, so as to say that the petitioner has consequently been visited with a stigma getting so attached to the rest of his career so as to lead this court to hold the order to be punitive. In above discussion and reason, submission of the learned counsel of petition into an order being based on those allegations relating to the misconduct on the part of the petitioner squarely portraying as blameworthy and such stigmatic is not acceptable. In the wake of aforesaid, the writ applicants stand dismissed. Having found there shall be no orders to cost him. I'll bring back to Lordship kindly. Glance at annexure.
No, you come to the first order.
First order of the single judge.
Single judge.
Single judgment.
What is that order? Access?
That is my lords.
90.
9. Annexure 9, page 89.
Annexure 9 is a representation.
91 to 90.
91. 91.
Yes.
My Honorable Justice Vishwanath Rao.
Yes, your lordship.
Okay.
In that, your lordship, 2 points were raised. Whether the KIT University comes under the purview of the state,
No, leave
That's
that.
the
leave
thing.
that.
and the second, my lords, page 165, your lordship.
No, you come to the, if you come to the paragraph number 1 of that petition order judgment,
Mm.
it has been mentioned that by filing this petition, the petitioner is an ex-employee so and so challenge the termination from service of the KIT University by order dated so and so, and consequential order so and so find person so and so, directing for sometimes formalities, also for vacating the quarter allocated to him pursuant to the termination. This is a direction in the nature of directing the opposite for supplying the document mentioned in this one. So then the 11th single judge, what has been held in the operative part.
Page 165. Para 165.
Read those part where this state is to have.
Coming directly to the last part of the judgment.
So was point called out by the honorable single judge to consider. What are the 3 points?
Para 26, page 164, your lordships.
That is regarding third point.
Third point. First two was regard to
What is the third point?
Third point is regard to whether the petitioner mellows.
Termination is illegal.
Termination is illegal.
Come to para 26.
Para 26 then.
Para 27.
26, read 26.
Now coming to answer point number 3.
Yes.
I find that the service of the petitioner was terminated by order
Where
dated.
these 3 points were mentioned in the
That's what I
judgment.
Para 12.
Para 12.
Twelve.
Page.
Page 102
102 what's like?
102.
of the brief.
102. Okay, without faster now, state problem. To pin down whether the order of submission can inquiry with opportunity of saying false to the victim before some. A point of
Principle of natural.
principle natural justice finding gone asla.
Para 25.
25, yes. 25. Read from 25. 25 and 26.
25 to 4 page or surrounding page.
162.
162.
Now, para 25. Now, coming to answer on point number 2, facts as borne out demonstrate that the university initiated an in-house inquiry against the petitioner, and the said in-house committee, admittedly holding an inquiry behind the back of the petitioner, appears to have arrived against the petitioner, via annexure C by 1, recommended the authority not to extend the petitioner probation, and KIT authority claims that it is only depending on such recommendation the authority passed order dismissing the petitioner from his service, via order under annexure 4. Since inquiry ended with a stigma and the impugned order of dismissal was passed, going away from the recommendation of the in-house committee and considering the fact the petitioner was a probationer, compliance of natural justice was the minimum requirement. Law is well settled by AR 1999 Supreme Court 1983, AR 2000 SC 1080, 2010 8 SCC 220, and the 2 decision of our High Court referred to in para N and O, holding that termination in case of a probationer also requires compliance of principle of natural justice, and the same having not been followed, the order of termination vide annexure 4 cannot be sustained. There is gross violation of rights under Article 14, 16, 19 of the Constitution of India. In 2010 8 SCC in para 43, the Honorable Apex Court has made it clear that finding against a probationer arrived at behind him, which found to be the basis of discharge order, such discharge order can only be passed after following the principle of natural justice. A similar view is also taken by the Honorable Apex Court as reported in AR 1989 Supreme Court.
All these judgments are reported and from 164 last day. Under the above facts, ruling,
and in view of settled that there cannot be termination or dismissal order in absence of non-compliance of principle of natural justice. Thus, point number 2 is also answered against the opposite party, university, holding the action of the university in terminating the services of the petitioner in absence of compliance of natural justice as bad and unsustainable.
Yes.
Now, para 26. Now coming to answer on point number 3, I find that the service of the petitioner was terminated by the order dated 26/2011 as appearing at annexure 4. Though the said order did not attach any stigma, but while answering to the pleadings of the petitioner, the opposite party number 1 to 4 in the counter affidavit submitted that before the order of termination, vide annexure 1 was passed, the case of the petitioner was being examined by an in-house inquiry committee who have an unanimous opinion that the conduct of Dr. Uttam Kumar Samant, the petitioner, has not been satisfactory and is highly unbecoming of a responsible faculty member of the university as clearly appearing at annexure C by 1. It is based on such report his service was terminated by annexure 4. Thus, in my considered opinion, even though the order of termination did not attach any stigma, yet in view of the finding of the inquiry committee as appearing at annexure C by 1, with the strengthening of the Right to Information Act and transparency in the actions, the future of the petitioner is very much likely to be jeopardized. As such, after coming to the above finding, which finding was arrived at by an internal inquiry committee held behind the back of the petitioner, law minimum requires compliance of natural justice by at least affording an opportunity to the petitioner before issuing the terminal order vide annexure 4. For this, the termination order vide annexure 4 cannot be sustained in the INF law. My such view also get the support of Honorable Apex Court decision AR 2000 Supreme Court 1080, wherein
principle of natural justice was supposed to be complied. Come to part 27.
27. In view of the findings on point number 1, wide paragraphs 22, 23, and 24, and my findings on point number 2 at para 25, and my findings on point number 3 at para 26, while allowing the writ petition, I set aside the impugned orders and annexure 4 of the writ petition, as well as the consequential order as appearing at annexure 6 of the writ petition. I further declare that the petitioner whose services has been taken out by order under annexure 4 be deemed to be continuing in service for the entire period. But since he has not worked for all this period, he may be paid 60% back rates. So far, petitioner prayer for direction to the opposite partner of 4 for supply of documents mentioned in annexure 2, documents internal such and such. In supplementary affidavit instance of petitioner, the appeals kit has already brought it under the fold of RTI and the petitioner liberty to praise the
So
service.
the termination order was set aside and the services is deemed to be
continued since 2014.
This is the consequence of
This was the since 2011 to the passing of this judgment.
Therefore, you say that since 1 year is already passed, so you
One
are
year-
a regular employee.
regular employee.
That probation period is already over.
That's as per their claim. My lordship, can you glance annexure 13, your lordship?
And so the subsequent termination, a departmental inquiry ought to have been contacted.
Done with
before
giving an opportunity rather than being rather than be taken consider I'm a probation employee.
Not by considering you probation employee, you should not have been terminated. A regular departmental proceeding ought to have been considered because of your misconduct, whatever. That is not followed. That's your whole case.
Whole case.
You say that this provision period, you have to actually complete that provision period. It's not that is there any question of deemed completion of provision period?
Lordship, I will
because
just
the 1 year period was there. The provision period which is there, that is for a purpose. Because the authority has to be satisfied during that period, that is your performance is good. And suppose you have not completed that period, you have completed only part of it. Thereafter, for your conduct, you have been removed. And then this, it was said that, so you are again to required to complete the balance provision period, or you will be regularized on the ground that because you filed a writ petition in the High Court, even though that provision period has not been actually completed by you.
With regard to
there is no deeming concept in provision. You will get the judgment where Supreme Court says that it has to be in writing communicated to you that your services are applied. If it is not communicated to you, it is deemed that your provision period is continued.
To that, my lord, there are two plans for argument. Your lordship, can you glance page 377.
High Court order, there is nothing that about touching all those vital aspects that this provision you have not completed, that it is to be deemed to have been completed merely because. So there is nothing like that in that order.
To that,
Deemed completion of probation is automatic regularization.
Yes.
There is no deeming provision, but deemed continuation is there. If they are not confirming, it deemed to have been continued.
To that effect, Your Lordship, may kind of annexure.
So the
34.
appointment letter, what is the
Well,
probation condition?
Let us see your appointment. letter.
Appointment.
Annexure 2, Your Lordship. Page 77. The bottom, my lords, bottom para.
Para two.
Para 2.
You
will be on probation for a period of 1 year. Full stop. Based on your performance and on successful completion of your probationary period, your services will be regularized. Now, Your Lordship,
So these two words are important. Your performance and successful completion.
As the KIT University comes under the purview of UGC, Your Lordship, UGC has filed their counter affidavit, and in that counter affidavit, they have stated that regulation with regard to this period of probation and confirmation. Lordship, may can you glance page 377, that is part of annexure 34.
Whether your petition, whether there was any such prayer that since I have just worked for this much of period, I have not completed the probation period in its entirety. It may be because of their laches, or I may be the order may be passed that it is to be completed that period.
That is there, ma'am.
Because there is no such order finding to that.
Finding in the impugned order is also not there, but my point of argument has been stated in the impugned judgment.
So
with regard to that
argument might have stated. Question is that you say that when this on the face of this appointment letter, where it has been mentioned that your probation period is for a particular period, and basing on two things. One is the performance, the other is the successful completion. Can this court, by any stretch of imagination or by anything, can reduce that period? Whether the High Court is empowered to reduce it?
Not empowered to reduce it, but then UGC guidelines.
How can you say? We are asking you a question that is there anything in their service, state university or anywhere, that suppose a person has not actually worked for a period of 1 year, even though the probation period is 1 year. He has, let us say, he has worked for 8 months. 4 months are still there. So can the High Court or anybody, or is there anything, it will be said that can be waived out, and it will be ordered that it is deemed continuous.
There is a judgment of the Honorable Apex Court also in that regard. Before that, no. Joined, I joined on 28/7. Thereafter on the 28/7/2010 I joined. 28, because offer letter is of 12/5/2010. Offer letter annexure 1, Your Lordship. 28/7/2010. 11, Your Lordship. First terminated, my lords, 26 2011. 1 month, my lords, left. First term. That the inquiry committee being malafidly instituted in my past following provisional.
And having said that, the single judge said that the judgment is not weak.
No.
So therefore, the single judge said that for the period from 2011 to
14.
60% will be paid.
Paid. No.
Since you have practically
not worked,
then the fact remains that you have not worked.
minus that is there, man. But also
That
the
is an ancillary relief given to you 60%.
60%.
So therefore, you are trying to stretch it because you have been restored to the position of 26/6/2011.
Yes, with that as that line matters. The honorable single judge's words are very clear and unambiguous, man. It says that I will be deemed to be continuing in service since 2011, man. It never stated, my lords, I will be reinstated. The honorable single judge has never stated that I'll be reinstated back to that position, my lords. Rather, it says that
there is nothing that there is indirectly or directly that period on that non-completion of that probation period has been waived off.
That line is not there. That
line is not.
Not.
You cannot say that suppose person has been stated that your probation period is 1 year. This court has not stated that it can be as a reduced or waived or something like that. So when you join, you go back to that stage that as if you are in that probation and you have to complete the rest of the period. And basing on the earlier that performance plus the subsequent performance, once you complete that 1 year, your authority has to be satisfied whether you have completed it successfully or you can be given some more time to complete it.
The probation period can be extendable subject to your performance. Performance, it is not extended. Your performance is
in their appointment letter.
The type of representation you give, bringing so many issues, complaining so many things, except teaching. Therefore, they are not satisfied. That's the reason they initiated. So the satisfaction part, which was a precondition for the purpose of regularity, is lacking in law.
Before going to answer that, Lordship may kindly glance at page 377. The counter affidavit filed by the UGC, wherein they have stated the period of the given the guidelines, the rules of period of probation and confirmation. Yes, Lordship. Para 11, my lords. 11.1. The minimum period of probation shall be 1 year, extendable by a maximum period of 1 year in case of unsatisfactory performance. First condition. Second, my lords, is that the confirmation at the end of 1 year shall be automatic unless extended for another year by a specific order before expiry of the first year. Thereafter, 11.4, probation confirmation rules apply only the initial stage of recruitment issued from time to time by central bank.
First is that can be waived out or that period can be reduced to monthly.
The first 11.1 it says, man, that is also not followed by the Kedo University. When there is not been an unsatisfactory performance on my part, it shall be extended, shall be 1 year extendable by maximum period of 1 year. It should have been extended to maximum period of 1 year. That was not done. In the 11.2, it clearly says that.
Saying that the single bench has passed the order, so there is no need to complete the probation period.
That is my
backing of this that at least
another point bank of argument.
It depends on the satisfaction of the authority. They are not satisfied with your performance. And are they bound to give you that extension period?
Yes, Your Lordship, because it says shall be 1 year extended. As per the UGC guidelines, the minimum period of probation.
Not today. After 2 days, you have been removed. You went to the court. After 2 days, you went to the court. Matter kept on pending for 3 years. After 3 years, that's set aside. And where is the opportunity for the authority to attain satisfaction? Because you have not worked at all. So the idea of the probation is enough time is granted to you so that the department can attain satisfaction on the basis of your performance. Where is the occasion? Because the matter was litigated before this court from 2011 to 2014. And there is no occasion for the Heat University to assess your performance.
I was not actually working. That is fact.
Idea of
Even they, in the office order dated 16/10/2014, also accepted my joining report, but they have
Joining it, they have accepted, but they have you have to mark the balance period.
but
Because the authority over whom you are working during that past period might have changed or might be different than the persons who are there versus your performance in the subsequent occasion.
Have they extended the probation period?
No, they have not extended. This simply says that as 1 year is being completed, which is in violation of the UGC guideline. UGC guideline says it shall be extendable for 1 year if there is unsatisfactory performance.
There you may have a case.
Moreover, my lords, I joined on 16/10/2014. On 15/11, my lords, they gave me an office order stating that I have not been attending the School of Biotechnology. My lords, nowhere they have in their counter also they have stated that any duty has been assigned to me with regard to an assistant professor of the School of Biotechnology. So with regard to assessment in the appraisal committee, my lords, even if their point of argument is that that I'll be on probation.
Period of probation. You have been assigned to particular duty, but you have to teach this student. And in this process, during that 1 year period, they found that you are not going to teach these students your performance is very poor. Are they bound to extend that for another year to see that whether during that period you are actually going to teach the student or they are at liberty going to terminate you because they may not extend you also. Because during that period you have assessed that you are not going to teach these things are factual aspects. You may say that I'm taking classes. Those are things we are not concerned with. We are in a point of law. We are in a point of law that suppose during that 1 year period, your performance, you have not done your duty. You have not taught the students. You are not going to the classes also. So
your entire case now rests on 11.2. Concentrate there. Don't go beyond here and there. 11.2 is the only point which may help you because there is no communication by the authority extending your probation beyond 1 year.
As 11.
Because it mandates that after expiry of 1 year, a specific order needs to be passed under 11.2, which has not been done.
No, not done.
So that is the only case you have so far.
And also
subject to
11.1 also.
Again, point is that whether they are bound to extend it.
As per the UGC guideline, they are bound to extend. 11.1 says,
even though you are not performing your duty.
Not performing because it says that because of unsatisfactory.
There is judgment where I can I argued one of the matter I must tell you. There they say that if the specific order is not passed even after expiry of 2 years and the probation is deemed to be continued, but there can't be deemed regularization, but there can be a deemed continuation.
Those are two different aspects.
Two different aspects. So you can concentrate in 11.2. You say that there was no communication to me extending my probation till they get satisfaction. If they don't communicate you in writing that your period is extended, it is deemed to have been continued. But there is no reverse theory. if they don't communicate, it can't be said that it is deemed to have been regularized. That's the distinction.
With regard
Find out those judgments.
with regard to that, I'm placing the judgment.
Yeah. What is the reference?
AR 1968, Supreme Court, 1210.
Much has changed thereafter, sir. Anyway, you are
Just
showing.
given by
Anyway, so, which paragraph?
paragraph 8 and 9, my lords. But before that, I may say, read out the facts of that case. These two connected appeals raise a common question of construction of Rule 6 of the Punjab Educational Service Class 3 rules. Dharam Singh and Devraj. Before the October 1951, Dharam Singh and Devraj, the respondent to these appeals, were junior teacher in district board school. The district board school were provisionalized and the service of the respondent were taken over by the Punjab state with effect from October 1. In pursuance 1950, in pursuance of a scheme of provisionalization of local bodies, schools in the state. On February 30, 1961, the governor of Punjab, in exercise of the powers.
Don't read that. Come to page 25. Right away. Last. Para 9. Last.
Para 9 members.
This is the ratio digit.
Immediately upon completion of the extended period of probation on October 1, 1960, the appointing authority could dispense with the service of the respondents if the work or conduct during the period of probation was in the opinion of authority unsatisfactory. Instead of dispensing with the services and completion of the extended period, the authority continued them in their post until sometime in 1963 and allowed them to draw annual increments of salary, including the increment which fell due on October 1, 1962. The rules did not require them to pass any test or to fulfill any other condition before confirmation. There was no compelling reason for dispensing with their services and re-employing them as temporary employees on October 1, 1960, and the High Court rightly refused to draw the inference that they were discharged from the service and re-employed. In these circumstances, the High Court could rightly held that the respondent must be deemed to have been confirmed in their post,
Yes.
though the appointing authority did not pass formal orders of confirmation in writing. It should be presumed to have been passed orders of confirmation by so allowing them to continue in their post after October 1, 1960. After such confirmation, the authority had no power to dispense with their services under Rule 6, Clause 3 on the ground that their work or conduct during the period of probation was unsatisfactory. It follows that on the dates of the impugned order, the respondents have the right to hold their post. The impugned orders deprived them of this right and amounted to removal of service by way of punishment. The removal from service could not be made without following the procedure laid down in Punjab Civil Service, such and such rules, and without confirming the constitutional requirements of Article 311 of the Constitution. As the procedure laid down in such and such was not followed and the constitutional protection of Article 3 was violated, the impugned order were rightly set aside by the High Court.
So once that period is over,
Months.
If written communication is not made to you, then it is deemed to have been continued. And thereafter, if it is terminated, a departmental proceeding must be. This is the law. But this law has changed. A different view has been taken. Just check it out.
My argument is that, Malos, when the
They are directly covered by this judgment, but now things have changed a little bit.
Plus, when the Honorable Single Judge in the previous writ petition, that order has not been challenged. Order has not been challenged nor modified, nor any modified to the extent that whether my period of probation is there. When the Honorable Single Judge clearly stated that I shall be deemed in service months, and they're paying me 60% back wages just because I was not working. So it should be considered that I have completed the probation period because I have worked for 5 years, 2010 to 2014 months, and I was given 60% back wages. They have rightly given me back also that 60% of wages also. So they accept this fact that as because I have not gone and ahead and taught Malos, it will be supposed that I was on bed rest or something on that point of view, and I will be deemed to be confirmed in service months, because if that order have not been challenged, Malos, by them in any form.
If your conduct is otherwise good.
If my conduct, Malos, that conduct was raised and that was set aside, man. And they also had an opportunity given by the Honorable Single Judge to raise that issue, but they did not raise that, ma'am. So they accepted this order, Malos. They have not challenged, not modified in any format.
Yes.
Yes.
Yes, madam. What is?
Lordship, with all humility, when 1717 was the first writ application, Justice Rothankar judgment. Now, your Lordships, probably that record is not there. In that prayer, I've got a copy of just the prayer portion of the references. I'm not reading it. Yeah, just see that prayer. ମୋ କପିଟା ମୋ ପାଖେ ନାହିଁ ହଁ ଅଛି Your Lordships, there was a specific prayer to actually quash 4 and 6. 4 was that first order of that your services come to an end.
Termination.
Yes, and 6 was as your services have come to an end, so please hand over the documents. He makes no consequential prayer here, specifically no consequential prayer. And then he makes a prayer for some document. And then this order is passed. Well, maybe my junior counsel has not put forth certain facts. This order of the single judge was carried in review by him. I mean by his client. Review was withdrawn. He carried in writ appeal. In the review, he makes a specific prayer that I shall be now confirmed in service not as a probationer but as a regular employee. He made a specific prayer in the review. I'll give a copy of that review.
That review is there, annexure 15.
ନାଇଁ ସେଇଟା ବୋଧେ ନଥିବ
Let's see, annexure 15.
ଦିଟା ରିଭ୍ୟୁ ହେଇଛି ତ ସେଥିପାଇଁ ଦିଟା ରିଭ୍ୟୁ
172 you're talking about.
Review number? Just give me one. That is 172 of 2014.
Yes, that is that annexure 15.
He makes a specific prayer there.
Let us see that.
That was annexure
Page 192 there.
of letter.
Enhancing 60% pay wage to 100%.
And I would
Along with the consequences and regularization of the petitioner service with effect from so after completion of the period of probation.
So he makes that prayer, withdraws it, carries in writ appeal. Writ appeal also makes these two specific prayers. Writ appeal is dismissed by a division bench of Justice Mahanti and Justice Chaudhary.
Where is that writ appeal prayer here?
Writ appeal order টা দিয়া হয়েছে
Writ appeal. You have not mentioned all these things in the date chart.
but the body তে ଅଛି but he did not really
You have mentioned it in the date chart also.
When is that 50 appeal?
Writ appeal.
That will be at
Yes, annexure 29. Come to 29.
105
writ appeal.
Same prayer.
Same prayer, and in that order, your Lordship will see this prayer is not granted.
No, where is that writ appeal order?
Order, ମୁଁ ସେଇଟା I've not written that page number, that is why I'm myself searching for that. Yes, ଅଲଗା ଅଛି କି ଅଲଗା ଅଛି
Writ appeal order ଟା file
ଅଲଗା ଅଛି your Lordship, I have it. 405 of 2000. This order is also reviewed and dismissed. ମୋ ପାଇଁ ଗୋଟିଏ କପି ଅଛି 155
writ appeal order.
255 ରେ ଅଛି 250 ନା 255 ରେ ସେ ରିଟ୍ ଟା ଅଛି କପି ବି ଅଛି ମୁଁ ଦେଖିଛି
Let us see the order.
ଅଛି page 250 ତା ପରେ ମୁଁ ଦେଖିଛି ନିଜେ
There was a contempt petition also.
ନା ନାହିଁ ମୁଁ ସେଥିପାଇଁ କପିଟା ହେଇଛି ନା ସେ ଗୋଟେ କପି ନାହିଁ ଏଟା ମୁଁ କପି କଲି ଦିଟା କପି that order is not there, but your lordship may see. Last portion. After discussing everything, the court finds that you accepted that first order which was passed after that single bench order. You accepted also the back wages. So now you cannot turn and say this that you and then your lordships, I also draw your lordships attention to section 11 explanation 1 IV and V of the CPC.
अच्छा ए ऑर्डर अगेंस्ट कोनी रिव्यू
See review कलो review टा भी dismiss है.
काई सी ऑर्डर था
say review.
It was withdrawn, man. Review was withdrawn.
No, first टा withdraw ହେଇଥିଲା, second टा dismiss.
ओधा
ଏଟା 111 ଟା ବି ଅଛି ଆଉ 170 ଦିଟା କ review ର order ଟା ମୁଁ ଦେଇଛି.
ए रिटर्न ऑर्डर अगेंस्ट
ହଁ 172 ଟା ହଉଛି
What happens is if the litigation is done by the in person, all these things happen.
ନା ସେଥିରୁ ଓକିଲ ଥିଲେ only 8 ଓକିଲ ନାହାନ୍ତି.
Warranty judges.
और the review of the judgment in 19th of 2017. So that's say 19th of 2017. हाँ इटा.
हाँ 111 टा हଉଛି
Judgment in question.
शेष review.
We don't find any reason for the review question dismissed.
172 ଟା ସେ withdraw କରିଥିଲେ writ appeal ନେଲେ.
Seeking liberty to so and so.
नहीं इटा
ତାପରେ ଯୋଉଟା ଜଷ୍ଟିସ ମହାନ୍ତିଙ୍କର judgment ଟା
against the defense.
So what I mean to say is that he was very conscious of this fact, made a specific prayer. And your lordships, I draw my attention, I'll just read those two explanations. Section 11 of CPC, which is on res judicata, and where these explanations deal with constructive res judicata also. So any matter which might or ought to have been made a ground of defense or attack in such formal suit shall be deemed to have been made directly and substantially in the issue of such suit. Any relief claimed in the plaint which is not expressly granted by the decree shall for the purpose of this section be deemed to have been refused. So the only remedy to that portion was Supreme Court. But your lordships, Justice Das did not stick to that technical ground. He went and he explained, he gave adequate reason that why that ground of yours is not sustainable. He gave it a merit also. So what I mean to say that this impugned judgment, that honorable judge has not dismissed, or maybe it was not brought to record or whatever, but has not dismissed none. And may I show that finding from that, from the impugned judgment? Para 9 re was all the contention of the opposition.
This judgment was passed in 2017, and this review petition was filed. I mean to say thereafter.
Probably that is why it maybe not. So, but what I mean is, anyways, these are also there side by side. This whole thing parallelly was also moving. So the petitioner's own interpretation of that judgment was that relief has not been granted, and I have not also made a specific prayer to that. So today the stand may be a little contradictory. And because of res judicata constructed in both, the court may keep that stand away. And if this stand is away, then what becomes the implication? But however, the impugned judgment still deals with it, and may I be allowed to place those portions of actions?
I don't think that when the this writ appeal was filed and the judgment was pronounced in 19/4/2017, this order was also brought to the notice of the division bench.
I think so, that is why probably.
এটা 17/2/2017 ରେ ହେଇଛି।
17/2
ରେ
ଜଷ୍ଟିସ ମହାନ୍ତିଙ୍କ ଜଜମେଣ୍ଟ ଟା ହଉଛି
ଜଜମେଣ୍ଟ ହଉଛି 17/2/2017 ଆଉ ଏଇଟା 2 ମାସ ପରେ 19/4/2017।
ହଁ, your lordship is correct. But anyways, that today they stare at him, na? Today they stare at him.
No, what my brother is
हाँ,
asking,
पूछिली कि that is why
that should have been pointed out to the
that एवढा सब
detective.
pending ଅଛି.
Uh,
But then I would give this a bow down to the single judge that therefore he has also gone into the merit and the not decided. But these facts I have to bring it today because this is also a division bench. Another division bench has passed, so because it's my duties on bringing it. Now your lectures will see para 9.
have you challenged this division bench order before Supreme Court?
No. Really? No, it was done. Review critical challenge or this. Challenge.
Because we are afraid if you interfere in this writ appeal, if we say something that may go contrary to the
declaration freeary thila, and that has been turned down.
kind of sitting appeal over the division bench.
Appeal judgment.
SLP filed.
SLP has been filed, but
କଣ ଆପଣ ଏଇ
ମୁଁ ଜାଣିନି।
ସବୁ ଏଗୁଡା ସବୁ କଣ ଜଣଉନାହାନ୍ତି ଆପଣ ଡେଟ୍ ଚାର୍ଟ ଅଧା ଦେଇ ଜିନିଷ ଦଉନାହାନ୍ତି what is this? We are
So many things has happened thereafter.
You see, you are not mentioning what is the result. You are not mentioning that you have gone to the Supreme Court. SLP ଆପଣଙ୍କର council କୁ ମଧ୍ୟ ଜଣଉନାହାନ୍ତି what is this?
Actually, what happened during Corona period?
Corona
during
Yeah,
Corona period.
no, the corona issue, that is not an issue. Issue is we are also division bench. Another division bench has passed some order relating to the same issue. If we take a view which runs contrary to the view already taken,
My lord,
it will create problem. And you have gone to Supreme Court, and Supreme Court has also dismissed. We don't know what had happened. So all this fact you have to bring on record.
I'm giving you the fact, my lord. This read appeal was hearing was done on maintainability as we can file the read appeal.
It is not, Mr.
Based on
appeal was not on maintainability.
maintainability. Yeah.
Addressed everything. Read appeal in the read appeal. If you come to your prayer portion, as rightly has been pointed out by the learned senior advocate, Mrs. Rotho, that your prayer there was also for regularization of the petitioner service after completion of probation period and promotion. That was also your prayer.
And pay
That
100%.
and pay
Instead of
50 to pay 100. So this has been totally turned down. So against when this order has reached finality, because you have gone to the Supreme Court, it has been confirmed. How can another division bench will pass at this stage an order that we should run contrary to the order passed in writ appeal?
Because it is a different cause of action we have approached.
What different cause of
because you have terminated second time.
See, that is you will
because
not
of the cause of
appreciate. You will
action
not
different.
appreciate that. Now you have a lawyer. He can understand, and you just go through this judgment and Supreme Court judgment and all. Tell us. We can't.
Please bring on everything. If you have filed the SLP, it is your duty to point it out.
You have to tell you have to read this judgment and understand what exactly.
How can you withhold this information from your
It's a
counsel?
very detailed order. Just
Please
see
put in your case.
19-page judgment.
Maybe it is a mistake. So I
mistake.
Don't do that.
Even writ appeal ଆପଣ ଖାଲି writ petition ଟା ଦେଇଛନ୍ତି ତାର order ଟା କ'ଣ ପାଇଁ ଦେଲେନି? ଆପଣ if you are annexing so many documents, you are duty bound also to, and why have you not also included that this review petition order?
maybe it missed out. Maybe
Entire thing actual aspect ରେ ଯାହା ଯାହା ଆପଣ step by step ନେଇଛନ୍ତି, ଯେତେବେଳେ ସବୁ ଜିନିଷକୁ ଆଣିବେ ନା କିଛି ଅଧା ଆପଣଙ୍କୁ ଯୋଉଗୁଡାକ ସହାୟ ହେଲ୍ପ କରିବ ତାକୁ ରଖିବେ ଆଉ ବାକି ଜିନିଷକୁ ଚାପି ଦେବେ?
Totally agree.
It's a duty to come fairly to a court in order to get justice, in order to get relief.
I agree, totally agree.
Equity demands that fairly it should be done. If you suppress anything from the court and court passes an order, suppose this matter would not have been brought to the our knowledge by learned senior advocate, what would happen? Would have passed an order which would have gone contrary to this and which has been confirmed by the Supreme Court.
Yes.
We follow a adversary system of justice. If you conceal something, the other side is there to point out. Don't think that it will go unnoticed. So please do that. Please do that.
That is not even, that is exactly pointing out to your counsel that in your date chart these things are not there. So please prepare another date chart and highlight in the all the things.
Nice.
Review petition withdraw kale bi taku lekhibe. तापरे एटा एटा सब सुप्रीम कोर्ट जाइछंदी ता देरे कोन पास हला ऑर्डर
Nice.
सबु ऑर्डर रो एवं तार कॉपी गुडा के दियंतु बाकी जोडा
Nice.
देई नांती
I'll file
just
the
file it.
along with
Maybe
the
if you can distinguish, if you can want to tell something, you can very
We
well
are
tell.
giving you a patient hearing. We are not,
Well,
but at the time we expect you to be
I beg apology.
fair enough
I beg apology.
because we are surprised that the proper instruction has not been given to you by your client. It is not your fault. We are pointing out to him.
You have done well.
But
Maybe it is my overlook. So
no. Question not. It should have praised you. You should have.
You brief properly, give all the papers.
I will file the relevant documents along with the fresh date chart.
And fresh list of
Fresh
date along
list
with
of-
the document which ma'am is.
Well, all the documents.
SLP number taka
And
this
then
was also
Adele, हाँ,
surprised
है
for
कि
me
नहीं?
that SLP which rightly fell from your logic. I think I should have also inquired.
Yes.
It is difficult. Na,
I will submit. I will give the
SLP रे कौन हला? This
date chart. I will
simple
give.
dismiss or something.
SLP number.
We don't know.
Ah, sir.
And the judgment which you have cited, there is contrary judgment, you just find out.
Well,
That has been taken note in this single judge order.
ये जो contradiction.
हाँ ये 1968 टा पूरा नहीं है सब नहीं है it's a very
contract नहीं है. See, extended नहीं है.
Parts one, so during course of argument, it is brought to our knowledge that challenging ये जो प्रथम रिव्यू अच्छा challenging the order dated 29/9/2014 passed in WPC number 17171 of 2011. One review petition was filed bearing number 172 of 2014, which was dismissed as withdrawn. And it was also brought to our notice by the petitioner, the review petitioner, and it was also brought to our notice that the petitioner filed another review petition, that is 111 of 2017, challenging the order dated 19/4/2017 passed in writ appeal number 405/2014. And the said review petition was dismissed. It further appears, though the petitioner has annexed the writ appeal copy in the writ appeal number 405 of 2014, but the order passed in the writ appeal was not annexed to this petition. However, Mrs. Rothol and senior advocate has produced the judgment and order dated 19/4/2017, passed in the aforesaid writ appeal number 405 of 2014, which was dismissed. And in that writ appeal, specific prayer was made by the petitioner just a minute. Not only to enhance the back wages from 60% to 100%, but also consequential benefit like regularization of his service after completion of probation period and promotion. Stop. It is also stated that against the judgment and order dated 19/4/2017, passed in writ appeal number 405 of 2014, the petitioner approached the Honorable Supreme Court in SLP, but nowhere, either in the present writ petition, writ appeal, or in the date chart, the same finds place. Since many things have not been mentioned in the date chart, the Learned Counsel for the petitioner. What is your good name, Learned Counsel?
Nityabrata Beuri.
First
Nityabrata Beuria submits that he may be permitted to file a fresh date charge and collect all the information from the petitioner regarding filing of different cases before this court as well as before the Honorable Supreme Court, and bring it to the notice of this court. Put up this matter on Quebec beyond the
Next week, next week.
And let the council decide. He is asking for 2 weeks. Come.
Quebec date for the
8th of December.
on
8th of December.
list this matter on 8th of December 2025 in the top of the list. Top of the list.
Read para 18 of reshaping order. May help me.
That also is not available with me.
No, the
Order of the writ
actually he has over enthusiastic problem. Yes. We are just coming within 2 minutes.
Item 2.
May I please your lordship, madam? The matter relates to that whether the municipality, how the municipality will sue and be sued. So on the last occasion, your lordship has directed, because it is a very old matter, whether anything survives. So my lord, the total claim is 4,500. Now the suit, in the suit is dismissed, it is not maintainable. Now in first appeal, actually the court said that it is maintainable. Now matter is before your lordship, so it will take long time. So that I have, the commissioner will write up that amount. Your lordship may dispose of.
Keep the question of law open and this.
Question of law, your lordship may decide for that.
No, we'll keep it open and this.
Your lordship may keep it. It will be decided in another appropriate proceeding.
We are.
I'm
this
for,
second appeal. This second appeal has been referred to this bench. The second appeal, which has been filed by the appellant Rajendra Patra, challenging the judgment decree dated 25/8/1998 and 9/9/1998 respectively by the London First Additional District Judge Ganjam Barampur in money appeal number 8/88 bracket rate 5/87 GDC order dated 2/24 has been referred to this bench to answer the following reference inverted comma whether the municipal can sue or be sued without being represented by any person. When the matter was listed before us on 29/10/2025, we asked the Land Council, Mr. Sahoo, who is appearing for Barampur Municipality
Corporation.
Barampur Municipal Corporation, to obtain instruction that in view of the passage of time, whether there is anything survives to be adjudicated in the second appeal or not. Mr. Sahoo, on instruction submitted that the suit was filed, suit or judgment with Inati, suit was filed.
It was filed in 1988, man.
First appeal judgment money appeal filed.
Suit was filed in 1979, man.
The suit was filed in the year 1979.
Right.
Suit means money suit.
Money suit.
Number 61 of 1979 was filed in the and the relief, the prayer was for
Recovery of an amount of 4,000.
An amount of rupees 4,000.
4,783, man.
4,783. That is mentioned in page number 3 of that Bishop judgment. 4,783.05 as the arrear. The Land Council for the municipal submits that in view of the paltry amount involved in the case, the municipal corporation is ready and willing
to write up that.
To write up the amount, and therefore the matter may be disposed of, keeping the point of law open to be adjudicated in appropriate case. In view of such submission, the second appeal is disposed of. However, the point for reference is kept open to be adjudicated in appropriate cases. Next.
Item 3.
Non appears for the petitioner. Are you appearing for the appellant? Non appears for the appellant. Yes.
I'm final application for amendment as per our lordship order. I'm filing the amendment application. The borrower and the guarantor is already party. The writ application.
Which order you are challenging?
The order passed by the Honorable Tribunal.
Tribunal DRT na
DRT. DRT.
Why have you not gone there?
Appeal. Why?
Appeal. It's a small piece. I have to submit, my lord.
You are the borrower.
No, my lord. I am the bank.
So you are the bank.
Yes.
So what order was passed by the London DRT against the bank for which you have come up?
And I get true.
Yes.
Come to the operative agency.
Had both the counsel and passed produced the record. During the case of argument, the London counsel for the respondent bank submits that the auction held successfully for raise 41.48 and 25 of the amount has been deposited by the auction purchaser.
No, come to the operative part. 105 though.
Yes, ma'am.
105 in view of the above facts and circumstances.
Yes.
In
view of the aforesaid fact and circumstances of the case, the discussion made above, respondent bank is directed not to proceed further till next date, and the applicant is directed deposit 11 lakhs by way of DD in favor of the respondent.
Two installment 11 lakhs paid.
Deposited. So, my lord, here is very small things, my lord. Whether we go for the SI Act or
you see the matter is also still sub judice before the DR. If you are agreed, the alternative forum is available.
Yeah.
Why have you come here?
If that
and the man has
already that order may be a precedent, the SCST people are affected.
The bank who has approached the DRT? The borrower has approached.
Yes.
So the matter is of the year 2025.
He's paying money, take it and finish it up. Or you are back. Why are unnecessary getting into technicality? You are interested in your money.
Yes.
And the court says that
have you initiated any proceeding for that? That surface I Act 13(4) online
auction thila. Auction को से stay करते ले. वाले जो SC/ST category रा property.
auction sale तो ही नहीं.
Auction successful लेगी जे successful.
But it can't be because SC/ST property. So he's paying money now. You take it.
अब पर deposit कर सकता नहीं 11 लाख टका. बाकी तार जा हो तो ये कर दियो. So लेखन. This writ petition has been filed by the UCO Bank challenging the order dated 1/9/2025 passed by the Land and Debt Recovery Tribunal Cutter in essay number 90 of 2025. Interim order dated 1/9/2025. The one interim application has been filed by the bank for amendment of the writ petition, but we find that in the impugned order to the writ petition, the London Tribunal has asked, directed the borrower to deposit ₹11 lakhs by way of DD in favor of the respondent bank in 2 installments. And the Land Council for the bank submits that the borrower has complied with the said order of the Debt Recovery Tribunal and deposited the full amount of ₹11 lakh as directed. Stop. There is no dispute that the SA is still sub judice before the London DRT. Moreover, if the bank is aggrieved by the aforesaid order dated 1/9/2025, he has also got the alternative remedy available in the approaching the DRAC. Therefore, we are of the view that this petition
limitation
and according to disposed of, it is open to the petitioner to approach to file appropriate application before the DRT for expeditious disposal of the SA. Yes, next.
Okay. Would like to.
Item 4.
4 to 7 identical matter where you just now I have received the copy on behalf of opposite party Kendriya Dal Sangathan for OP 1 and 2.
and I will file Oklatnama within a week, and matter may be listed on 8th because another
These are
matter.
the only 4 matters, or there are other matters?
Monday.
Monday, one matter was listed.
Matter was listed. And
Yes,
there was another
yes.
one.
Give that number.
Yes, and WPC number 28979.
WPC number
28979 of 2025.
of 2025.
Yes, ma'am.
When that matter is coming?
What order was passed in that?
And that order was passed. No issue notice.
No, ऐसे order to the Bharat से order.
Issue notice and counter
Just
date fixed to 8.
one. Find out that order WPC number.
28979.
Yes. WPC. दुई आठे नौ साते नौ year होची 2025. সেই 10,000 সেই অর্ডারটা বার করে দিও, কপিটা বার করে দিও।
Madam, you should have come with this order.
Yes, my lord. I have.
I am upload.
Yes.
This is your job. We are doing.
Yes. I am feeling so.
Upload मार दीजिए।
These are minimum.
Yes, minimum.
लिखो दो। Manasi Mahapatra, Land Counsel for the petitioner is present, and Mr. Hrusikesh Tripathi, Land Counsel
For the Kendra Vidhala 1 and 2.
for the.
In all the 4 cases, he has not made party to the union because they are
filed. Have you filed?
No, just now he has
submit that
within 1 week.
He has instruction to appear for both the opposite party.
Both.
And he will file Wakalatnama
within 1.
The Land Counsel for the petitioner submits that similar matter is sub judice in WPC number 28979 of 2025 in the case of Sandhyarani Mahanti versus Union of India, the others. And on 10/11/2025, notice has been issued in the said case.
Date of judgment of each one is different.
And date of judgment
for that Union of India was also a party, but he has not.
Here
Not made
he has not made party. But in the tribunal, Union of India,
No.
I have to verify from the way whether party or not because he has served the copy just now.
Since a copy of the writ petition has been served on the Land Counsel, Mr. Tripathi, in court today, who seeks some time to go through the same and file counter affidavit. Court of this matter in the week commencing from 8/12/2025 with WPC number 28979 of 2025.
All are individual. Order also separate order passed by the tribunal and separate writ filed, separate counter and separate cause. Individual has to pass, not to batch case.
Batch case no je.
Same cause of it.
Asu nor pune olga scattered hi rahi stock counter if any be filed in the meantime after serving a copy of the same on the Land Counsel for the petition.
Madam, you have not filed OA copy, counter copy, nothing.
Not OA copy, not counter, additional counter.
We understand.
The Land Counsel for the petitioner shall file in the meantime the copy of the original application, the counter affidavit, and rejoinder file.
reject and other documents.
Entire reading which was before the London Central Administrative Tribunal. Original application and the entire reading before the London Tribunal. Matter to fix up allow you kebegala
8 December.
Similar order in this 5, 6, 7 3 name of the land and council. Upon you are to file within 1 week. And the name of the land and council for the opposite parties be reflected in the positive transport. Yes.
Public.
Item 5.
5 बोला बरा 3, 4, 5, 6, 7 पड़ेला 8 नंबर तक.
Item 8.
Yes.
Let the order will not get at annexure 21, page 126. The order passed by the recovery officer of the learned DRT issuing a warrant against the petitioner. Annexure 21, page 126, and also will get the relevant portion of the order 128. In view of the continuous and willful default.
The recovery officer's order, you can challenge that in the DRT.
No, what happened, my lord? Here, my lord, we have no objection.
Whatever, but you can challenge recovery.
No, now they are insisting for the statutory deposit. Statutory deposit means the amount involved in the award. That is the whole difficulty. He cannot.
The question of law is that whether you have got alternative remedy or not. So my esteemed father is pointing out.
No, that I'm conscious about 127.
So the provision recovery officer against order against pay upon a DRT
27. That is there, my lord, but they are now insisting for statutory deposit. That is
to move an application for waiver. If it is rejected, then you can come. Why you are contemplating that this order will be passed?
Which is the provision?
27.
20?
Section 27. 30. 31. Appeal against the order of recovery officer.
Power of the adjudication. 30 of
30 of recovery of debts and bankruptcy act 1993.
30 A B M T achi kota.
30.
30. No portion. Take cognizance. Eta roche.
That's what it's a bankruptcy act 1993.
Recovery. 30 section 30.
You move an application for waiver.
If that
rejected, then you have a cause.
Section 30.
Because one occasion that situation happened, that another order was challenged.
No, right, yes, the petitioner has filed the petition challenging the order dated 22/10/2025 passed by the recovery officer DRT Cutter.
In RC number 97 of
in RC number 97/2008/CTC. Inter alia issuing warrant of arrest.
Warrant of arrest
Against the petitioner.
One of the guarantors.
Who was one of the guarantor in the loan transaction. So, Section 30 of the Recovery of Debts and Bankruptcy Act 1993 reads as follows. Quote the entire provision. Since there is alternative remedy available for the petitioner to challenge the aforesaid order of the recovery official, we are not inclined to entertain this writ appeal, writ petition, which is disposed of.
If any application for waiver is filed, that will be entertained.
And counsel for the petitioner submits that whenever such application is filed before the Lanen appeal is filed before the Lanen DRT, challenging the order of the recovery officer, the Lanen DRT is insisting the person, the appellant, to deposit the entire amount.
The statute at 50%.
To deposit the 50% amount of the 50% of the
award.
Award, yes.
Requirement of
It is he further submits that the petitioner may be permitted to move an application to reduce the same in view of these financial stringency, in view of his financial difficulty in depositing certain amount.
I have no objection if the property they have taken, because it has already been put to auction.
File such application permissible in accordance with law, which is to be done. Yes, next disposed of.
Item 9.
I challenge the initiation of the original application by Bank of Baroda. And my case is that it is contrary to section 11 and as well as the law declared by the Honorable Apex Court in 2025. The brief fact is that the two banks financed me in the year 2012. I could not maintain.
Prayer is
to quash that
original application filed for the DRT.
Yes, sir.
That is of the year 2015.
Yes, ma'am.
What is the status now?
No, it's still pending.
Who has filed that application?
That's Bank of Baroda. Bank of Baroda.
Who are you?
I am the loanee. So I'm just placing my note. What has happened here?
What is the status of that case?
That's still pending, madam.
Pending, madam. What is the order sheet?
The order sheet is
you don't know.
It's pending, my lord.
Pending on the parts of income.
All these things you have to tell to the DRT now. How can we quash it?
Exactly. What has happened here is what is not in dispute is that more than the demanded amount they have recovered.
These are factual disputes. You are seeking quashing of.
I'm not seeking any factual dispute. I am on admission. In 2013, they sold my property for rupees 31 crores as against the demanded amount of rupees 30. There are two banks who has financed me. One lead bank is Punjab National Bank and the other one is Bank of Baroda. Their total demanded amount was 30 crore. They sold my property for 31 crore. Now, Punjab National Bank being the lead bank, he is not appropriating the amount with the Bank of Baroda.
Just answer, a recovery proceeding initiated by a bank in a due process of law can be quashed in a jurisdiction. Answer it.
My lord, yes.
How can you be answer?
I'm sorry. My lordship may kindly have page 60. That's the allegation. Page 60, that's the OA allegation. My lordship kindly have that. Page 60. In the meantime, may I just place my lord?
60.
Yes, my lord. That's the OA, the allegations in the OA. Paragraph 20, my lord. In the meantime, may I just place my lord?
It is the nature of a suit.
Well, exactly, that cannot be done. That
you
is
can file a writ petition saying that terminate that suit.
Well, that's 711. Lordship is correct. This is absolutely not maintainable. And so the provision.
You move appropriate.
I will show the provision, my lord, and also the judgment. Lordship kindly have paragraph 20. In the meantime, this is the admitted position. I'm not bringing any disputed situation. This is bank's position. In the meantime, the applicant and defendant.
Where are you reading?
My lord, paragraph page 60, paragraph
20.
60.
In the meantime. Yes.
In the meantime, applicant and defendant number 7 initiated actions under Securitization and Reconstruction Sector 2002 against the defendant number 1, issuing the notice under section 13(2) of the Surface Act on 1/6/2013. The defendant number 1 has failed to respond to the notice. Thereafter, the mortgage property was sold sold. Though in the meantime, the sale proceed of rupees 31 crore has been recovered by defendant number 7, that's Punjab National Bank. But till date, the said proceeds has not been appropriated in the account maintained in the applicant's branch, as the proceeding under the Surface Act has not been finalized. Now, my lord, I am drawing your lord's attention to section 11. What is the dispute? The dispute is that the two banks unable to share the portions of their sale proceeds. That's the dispute for which they are filed. Now, your lordship,
you are absolutely correct. Why have you not application before DRT?
Well, your lordship can have section 11. I allow it for 1 minute.
Section 11 says don't move application.
Section 11, your lordship can have. Section 11 of the Surface Act.
It is in the nature of 711 application.
It is their situation has to be in arbitration. That cannot be by word. That's what the section 11 mandate. The lordship can have resolution of dispute. It's through arbitration. Therefore, it's ex facie without jurisdiction. That's what my case, man.
Yes, still.
Yes, my lord. 11 of Surface Securitization Act. Where any dispute relating to securitization, has your lordship got it? Yes, ma'am. Where any dispute relating to securitization or reconstructions or non-payment of any amount due, including interest arising amongst any of the parties, namely bank, financial institution or securitization company or reconstruction company or qualified institutional buyer, such dispute shall be settled by conciliation or arbitration as provided under the Arbitration and Conciliation Act 1996. Yes. As if the parties to these disputes have consented in writing to a determination, the requirement of section 7 has been referred here. Now, this issue has also been there before the Honorable High Court, Supreme Court in 2025. I have annexed the judgment, my lord, that at page 178, the exact issue. And the Honorable Apex Court has concluded it's only and only arbitration.
So therefore, you say because of section 11
yes,
in Securitization Act,
yes, madam.
DRT application in section 19 has to be dropped in a writ petition. That's your case.
My lord,
what is this?
My lord, where should I go, my lord?
Of the first degree.
My lord, they admit themselves that, and then what? Where should I go, my lord? That's my.
You move application there 711 saying that because section 11 is staring at the face of it. Drop it.
I have been moving this application. I must say, I have been moving that, not taking up. Your lordship,
directing this
yes,
petition has been filed.
That's better.
By the so and so by the petitioners, for following this.
Lordship, I consider only prayer number 1.
Inter alia, for issuance of writ of certiorari passing the original application 171 of 2015 pending before the plan and DRT cutter. Mr. Rotong and Council submits by referring to section 11 of the FSI Act 2002 that in view of such section, the dispute needs to be settled by the under the provisions of Arbitration and Conciliation Act 1996. And since the same has not been done, the original application is pending since 2015. Therefore, it should be passed. Section 11.
With permission, Milord, I made the excuse in Milord.
Reads as follows: quote the section.
Milord,
placed the decision of the Honorable Supreme Court in the case of Bank of India versus the Bengali Rice Mills and Private Limited and others, reported in
2025
volume 95 SCC online SC 1229. Wherein Honorable Supreme Court, paragraph 2 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 paragr
82.
My lord, with permission, excuse me, my lord. Here, my lord. The amendment come in 1st September 2016, my lord.
Paragraph number 82. It has been held as follows. Quote kar diyan to paragraph number 82.
At page 221.
Take one paragraph no?
Well, in fact, the issue has been taken from paragraph 62 onwards. It is answered.
Object of the voice. And this has been answered in paragraph number 82.
Yes, madam.
Right. The Land Council for the petitioner submitted that you have already approached the DRT on this issue.
Yes, madam. And my application was also dismissed.
The Land Council for the petitioner submits that such an application to refer for the resolution of dispute under section 11 was brought to the notice of the land DRT by filing an application by the petitioner. But
the same was dismissed because bank has not filed the counter on this ground.
But the same was dismissed on the ground of non-filing of counter affidavit by the bank. Be that as it may, from the order sheet, it has been annexed the writ petition as annexure 13 series. We found that the case was adjourned on different dates, either for the absence of the land and presiding officer or for adjournment sought for by the parties. Since the original application is of the year 2015 and it is stated that the pleadings are complete, stop. The land and tribunals are to the needful to expedite the hearing of the original application.
Well, my application, original application, so that's jurisdiction. I will
conclude the same within a period of 3 months from the date of production of the certified copy of the order, if there is no other impediment. It is also open to the petitioner bring to the notice of the land and DRT the relevant provision under section 11 of the Surface Act, so also the citation of the Honorable Supreme Court by moving separate application accordingly.
That will be decided ahead of the.
Yes.
You have a counter claim also.
Yes, next.
That application will be decided prior to that OA and within the time.
That application.
3 months.
On behalf of PNB, my presence may kindly. On behalf of PNB, because PNB is one of the two opposite party numbers.
Just a minute.
PNB is in
Tunasa Land and Council appearing through virtual mode. That his name will be reflected in the order, though he has not argued anything.
Miller, with the excuse.
Excuse me. Tunasa Land Council appearing through party number 2 is present. Yes, next.
Position notice already issued annexure 4 mailer. The home loan and the petitioner was now 69 years old lady mailer. Home loan of 2,75,000 lakhs. Out of 1,70,000 already paid. Annexure 5 I have already approached the authority. That may be considered.
Who stage
position notice.
Position notice already issued.
Annexure 4.
So it is only section 7.
The writ petition has been filed with so and so. It appears that where is that notice? Annexure 4 position notice has been issued
on 25/9
on 20 date on 25/1/2025 under section 13(4) of the surface. So this one automatic memory is available. Disposed of. Yes, next.
My name.
Only paid. I approach 1 lakh. Demand is 1 lakh. Already approach repetition is there. That may be considered.
Yeah, it is open to the petitioner to file appropriate presentation also before the bank for amicable settlement of the dispute. Yes, next. Next.
Item 11.
Order passed by the Lord and Chief Judicial Magistrate Khurda, my lord. Who are you? I am the secured creditor. I filed an application under Section 14 of the Surface Act. Order that is rejected, my lord. Why? On the ground that I approached the district magistrate after 12 years of sending the 13-2 notice. And second, come to that order, my lord. Page 85 is the operating. 85. 85 to my lord. Well, the case record is posted for hearing. The Law and Counsel for the applicant is present. Heard the Law and Counsel. The present case has been filed under Section 14 of the Surface Act to take possession of the secured asset in order to recover a sum of rupees 15 crore 37 lakh 19,160.52 from the respondent. The petition filed by the petitioner revealed that the loan account of the borrower respondent has been claimed as NPA on 31/12/2011. The notice under Section 13(2) of Surface Act was issued on 15/3/2013 against the respondent, which is about 15 months after the loan account being declared NPA. The possession notice under Section 13(4) of the Surface Act was issued on 2/9/2021, which is about 8 years after sending notice under Section 13(2) of the Surface Act. There is no satisfactory explanation as to what prevented the applicant not to send notice under Section 13(4) of Surface Act within a reasonable period after issuance of notice under Section 13(2) of the Surface Act. It creates mere surmises and conjectures since the petitioner has approached this court more than 12 years after issuance of 13(2) of Surface Act. Further, on being asked, the Law and Counsel could not produce the up-to-date account statement in support of the claim. Besides, he failed to produce the notice under Section 13(2) of the Surface Act and postal receipt, postal tracking report with regard to sending 13(2) notice of the said act. Considering the aforesaid discussion, the petition filed by the petitioner being devoid of a merit stands rejected. So you are the successful. No, I am the secured creditor. In fact, I am the asset reconstruction company. Okay. Initially, the loan account was held with a bank. Subsequently, it was assigned to me, and I took over the loan and I proceeded under the Surface Act.
Your recovery agent.
I am the asset reconstruction company under Section 3 and 5. No, is there any limitation for filing this? No, madam. There is no limitation for filing section.
Doesn't say also within reasonable time. That also doesn't.
That appears that
No, say that there is, within reasonable time you.
No specific period is prescribed. 14%. When you are handed over this property, when you are, I mean to say, assignment was done. 26/4/2014. Property सेमती रही ना ऑप्शन नहीं किसी नहीं property सेमती अछि. In fact, two sets of property, one under the Jagatsinghpur district, one in the Khurda district. Jagatsinghpur district, we have got the permission from the district magistrate. But here in the come to 14, my lord. Section 14, my lord. Where the possession of any secured asset is required to be taken by the secured creditor, or if any of the secured asset is required to be sold or transferred by the secured creditor under the provisions of the Act, the secured creditor may, for the purpose of taking possession or control of any such secured asset, request in writing the Chief Metropolitan Magistrate or the District Magistrate within whose jurisdiction any such secured asset or other documents relating thereto may be situated or found, to take possession thereof. And this property situates within the jurisdiction of Khurda district. There is no dispute to that. Okay. Yes. And the Chief Metropolitan Magistrate, or as the case may be, the District Magistrate shall, on such request being made to him, take possession of such asset and documents relating thereto, and forward such asset and documents to the secured creditor, provided that any application filed by the secured creditor shall be accompanied by an affidavit duly affirmed by the authorized officer of the secured creditor declaring that the 9-point declaration is thereafter, my lord. That first is the aggregate amount of the financial assistance granted and the total claim of the bank as on the date of filing the application. The borrower has created security interest over various properties and that the bank or the financial institution is holding a valid and subsisting security interest over such property, and the claim of the bank or financial institution is within the limitation period. You come within the definition of the secured creditor because of that definition 2ZB. 2ZB would be as well. ZD হবো সেটা secured creditor my lord 2ZD not B. D for Delhi my lord. Any bank or financial institution or any consortium or group of bank or financial institution holding any right, title or interest upon any take down. The writ petition has been filed by the petitioner to set aside the order dated 25/4/2025 passed by the Chief Judicial Magistrate Khurda in this case number 151 of 2024, which the application filed by the petitioner under section 14 of the Surface IR to take possession of the secured asset for recovery of a sum of rupees 15 crores 37 lakhs 19,160 and rupees and 50 paisa was dismissed mainly on the ground that the petitioner has not approached the Chief Judicial Magistrate within a reasonable period after issuance of notice under section 13(2) of the Surface IR and approached more than 12 years after the issuance of such notice. The Land Counsel for the petitioner submits that the petitioner acquired the right and interest in the financial assets from Chatpuli Syrian Bank Limited and is considered as a secured creditor within the meaning of section 3ZD of the Surface Act 2002. And there is no such provision in section 14 which empowers the Chief Judicial Magistrate Khurda to reject such application on the ground of delay. Therefore, the impugned order is not sustainable in the eye of law. Issue notice on the question of admission, indicating therein that the matter shall be disposed of at the stage of admission. Requisites for issuance of notice by speed post with proof of delivery shall be filed within a week. A day after tomorrow. By day after tomorrow, foot of this matter, 4 weeks after. Counter affidavit, if any, be filed in the meantime. Yes, next.
Item 12.
12, my lord. Yes, Mr. Patnaik.
Yes, yes, my lord. My lord, I am the guarantor. The guarantor took a house loan of 25 lakhs, my lord. Thereafter, that property was given an extended mortgage, my lord. And my lord, the mineral company.
You are challenging against the DRT order.
DRT, my lord.
DRT, the matter is still sub judice.
DRT, the matter, what has happened, my lord. when my mortgage property of a guarantor was put to auction, my lord, thereafter I moved to the DRT. And I also filed my IA application to stay the auction and that the property, the physical
has been filed by you.
Yes, my lord. Essay was filed by me along with an IA, my lord. That IA was kept pending for 3 months. Just before the disposal of my IA, the bank filed a objection saying that sale certificate has been issued. And thereafter, my IA was disposed of, my lord, by page 36, Annex 1.
What was the purpose of filing that IA?
IA to stay the entire proceeding because I was agreeable to pay the
Once
entire.
the sale certificate has been issued,
My
no interim order has been passed. You have to implead the person who has.
No, my lord, kindly see the entire cavalier attitude of the bank and entire thing, my lord. What the miscarriage of justice has taken.
Is there any prohibition? Because
my lord, for 4 months, for 3 months, my lord, I was trying my best to get the matter listed before that court and to be heard by that court. But my lord, DRT didn't take up the matter.
And that the DRT did not take up the matter. You are insisting to take up the matter. But fact remains that in the meantime, sale certificate has been issued.
Yes,
third party interest has been created.
We have included them as a party over.
This court also passed an order.
Yes, ma'am.
Directing the bank.
Yes, my lord.
To proceed and
to proceed, my lord. There, my lord, the bank has 34 items. 34 item is similar to this, sir, because they come forward to this honorable court saying that the physical possession was not handed over.
34 may be also taken up together, my lord, for better appreciation of the case.
The order is also.
Because the interim order of the DRT.
This court has to avoid the position.
My lord, now what has happened? Another, my lord, the valuation of property is like some more, is like 4 crores.
Mr. Patnaik, whether the pleadings have been completed here, they are.
Pleadings, my lord, no, my pleadings has not been completed.
So,
only, my lord, they have filed their objection to my IA.
All right, it's all right. Now the IST is over.
Yes,
the main petition we are directing that the pleadings should be expedited, completion of pleadings, and then it should be decided at an earliest. That's all we can.
My lord, because my position will be there, there will be no position.
You are required to also implead that person.
I will implead, my lord. Here I have impleaded. Now, my lord, because my lord, for the first time I came to know when this sale certificate was issued. That order is there. My lord, kindly see. My lord, when that sale certificate, when that objection was brought on the record, my lord, for the first time I came to know that
interim order, it is very clear. They were aware third party rights have been created. In the essay, my lord, there was no challenge to the section 14 order. In the interim order, also,
in item 34, you get yourself implemented.
We have filed an intervention application over there. It is undervalued property. Yes, no, that's because my lord, of property which is for laughing cannot make your case stronger.
Possession,
where is your IA, Mr.
Not required. I have not received a single notice, my lord.
If you speak like this,
no, let him speak, my lord.
Why?
Hold on, Mr.
Speak, let him speak.
We just want that let both item number 12 and item number 34 be considered together, and you have filed an interim application. Let it be, will permitting you to be intervene in this matter.
There is no cause of action.
This writ petition has been item number 12. This writ petition has been filed by the petitioner so and so, challenging the order dated 30/10/2025 by the learned DRT Cuttack in essay number 160 of 2025. Kete number cheda annexure kete?
My lord, one, my lord. Impugned order is 1.
In which the learned DRT
and my lord, Annex 1, page 36.
In essay number 160 of 2025 has dismissed the interim application filed by the petitioner, filed IN number 1349 of 2025, in which a prayer was made for a direction to the bank, bank not to take any further action in respect of the scheduled properties pursuant to the e-auction
notice, my lord.
notice. Stop. The London Council appearing for the bank, Mr. Mishra, Subrat Mishra submits that in the meantime, the auction sale, that no interim order was passed in the interim application, and the bank has completed the auction sale, and sale certificate has been issued in favor of the
Auction purchase item 34 petitioner है
in favor of one Mandakini Rao, in favor of the Mandakini Rao, who has approached this court in WPC number 29196 of 2025, in which the petitioner Jajati Kesari Jena has filed an interim application, filed IN number 20021 of 2025 for intervention. Stop. In view of such submission, list this matter WPC number so and so with WPC number 29196 of 2025 on Ajihalla 17 तारीख 17th of November 2025.
In the meantime, can I pray that he give a
Ajay, you give a copy. Let Mr. Patnaik hand over the copy of the writ petition to Mr. Mishra, who is appearing for the State Bank of India. You file your
Also to me,
I have been made anyway party.
Yes.
And since Mandakini Rao, who is the petitioner in so and so, has also been arrayed as a opposite party number 5 and 34 now. And Mr. Bishwal has instruction to appear for the said opposite party number 5. Let a copy of the writ petition be also served on Mr. Bishwal in the meantime. Yes, next.
My lord, the interim, can I pray something?
Interim 14, he has already positioned it.
It
It
should not be registered. It should not be registered. Automatic on सब automatic है जो undervalued property करी तो नहीं हो.
This is appealable.
But IMFSC appealable, then why you before?
Anyway, we have this one merits on the next one.
Bank has to maintain a balance, my lord.
Rest of the matters in
Friday. Item 20 টা Friday
Friday पर आपसे
orders ने ऐसे रहती
होना.
मैं mediation जाकर कला you know से heard that
final disposal matter होना order से कौन है?
item 20 ऊपर orders ने ऐसे भी
Case admission order. ये गोटे फाଳ से कौन criminal appeal गोटे ये ले सेमती होगा परिया.
2012.
The eye is dismissed with some observation.
I agree.
Item for judgment, item number 2, WPC 28732 of 2023.
By relying upon the judgment of Janaki Raman and as well as Doli Loya and our own judgment passed in Ashok Kumar Panda, we have dismissed the application.
I agree. The interim application, the person is the concerned applicant is suffering in the jail for about last 2 months, madam. Instead of that, neither he has been referred to the hospital, he is only treated in the inside the hospital. That's why madam is condition suffering, madam. And what he is suffering? Madam, pain from the chest. He has not been taken to the medical. No, he has been taken. He has been taken to the particular. He has been taken to the DHS Vanipatna and also kept inside the jail hospital. And doctor is also because of the lack of equipment, everything. The disease has not been the disease which he is suffering has not been diagnosed for which he is suffering.
My lord, pardon to mention, my lord, one jail appeal matter, appellant in custody for more than 10 years, my lord. And another matter, appellant is aged about 73 years and the custody since last 4 years. Another CRLA matter for IF bail, my lord.
Obviously. The matter where the person is considered more than 5 years in custody. It was listed before my lord about 4 months back, and it rolled over, my lord. Now it has been delisted, my lord.
I have 2 appeal bail applications now. I want to make you mention, your lordships, 2 criminal appeal matters. The appellants are in custody for more than 11 years of bail, your lordships.
Pardon, your lordship, item number 9 may be kindly be adjourned.
I wanted to make a mention.
My lord,
in 47.
we comment sheet 27 October there, CL 2025 23.
1 minute. Item 47, my lord. This was there 8 weeks ago, my lord. It has been not reaching, my lord. It is further pushed to 47. It was since 25 then. Now, may I pray, my lord, Friday, if it could be taken up earlier?
Yes, Mr. What do you say?
Mr. Tripathi.
My lord, we comment sheet 27 October 2025 CL 2025 23. 13 year custody, my lord.
What is the number again? Be slow.
CRLA 2025 23. 225 by 23. CRLA 225 of 2023.
225 of 2023.
ठीक है जी, yes. I would come here. We'll call the matters.
47 is
you will see that.
Supplementary list. Item number 1.
The appellant has convicted for life on OSX 302. This matter may call for the
So, appellant.
Yes.
I would admit call for the trial court report. Interim application for realization of fine. So also the interim application bail shall be considered after receipt of the trial court report. Yes. Next.
Item 2.
May I please? Appellant convicted on section 302, 34 of the Indian Penal Code. Undergo RI for life imprisonment.
So, appellant. Same one. Yeah.
Item 3.
Please SCRL reminder 302 live.
Delay condom. They were order to admit they kill a তারপরে তাদের ফোন করে কচুরি গিয়ে 100 এটা কোর্টটা লাইফ ইমপ্রিজনমেন্ট
Nine. Live.
delay condom admit yes next
Item 5.
4. Okay. 4 men. The CRL mailer 177 302 live men.
no this man the name is appearing Milan Behra so report file huh now বিশেষ মিলন বেরানো লেখছে মিলন বেরা কেত নম্বর এটা নম্বর जो पैनल लिस्ट है कंपेयर कौन भाई रखूं हाँ कौन है मगी को तो वाणी
Item 4 mailer.
yes
Item 4.
हाँ कौन है
SCRL mailer that admit 302 mailer.
हाँ we have engaged somebody he is not appearing so what is the name of that council Milan Behra yeah could have এটা ये dictation नहीं थे Mishra list very much with
The 54 man. The serial number 54. 50. Last.
people कौन 54
Panel list में.
तो जगन्नाथ भुइया लिखा है
You have a different list.
No. The 28/7 list है मैंने. 28 and 23 list.
এটা তো 22/2/2023 ଆପଣଙ୍କର କୋଉ ଲିଷ୍ଟ ଧରିଛନ୍ତି
এটা जो ଏବେ latest जोड़ा है.
हां
Latest जोड़ा 28/7/25.
लेटेस्ट लिस्ट କାଇଁ
28/7/20. ଆପଣ ଫୋନ କରି ପଚାରୁଛନ୍ତି ତାପରେ ଆସୁନାହାନ୍ତି
लेटेस्ट लिस्ट if we have not granted him bail, how he has gone outside? That supposes that he must have been released by premature release.
28 years.
Apu कैसे कहना पड़ेगा आपको? गोटे पशु हमें बेल देइनु वर्तमान से गाय आपन लोग अछि आपनकर आईएसी पूछि से बाहर ता घर को अछि ते बाहर गला केमती प्रीमेच्योर रिलीज और की उपाय नहीं दीपक मैन so what is your instruction? Premature release है हमें केस का डिस्पोज कर दो ना. Why this matter is pending in the High Court?
You may also make some efforts. You can't keep on making all these things you are requesting negatively.
Well, superintendent गुड़ाका अपन तो इनिशिएटिव जीरो कहते ना आपकी कोर्ट में दे रही है एक बड़ी सुविधा को Parijit. Oh, huh? Why he has gone to our house? Huh? Milon Bera Lekhaji appears to be a male person. How it has been written that Mrs. Milan Behra? We look on a phone. A number logele, phone number. Give him a call. Number. He was in which jail? We do not know what amount has been paid to the state council per month.
We have minimum expectation from AG office, little assistance. Otherwise, there is no end. We are not able to hear any appeal. Only dealing with these bail applications and all.
ना गोटे मेरिट रे पचाला कोन कहउचंती matter you are dealing and this is the response. हम सोला फाइल फॉरवर्ड दिया चलो मोरू जोना पुनिका in this regular outlaw additional session the status or so on special jail special jail special jail राउरकेला लिखाई लगान तो कौन आई से सुपरिटेंडेंट को अपीयर करियो मिलन बेरा लगेले
With all information, whether premature release or what else.
next
Item 6.
It's the appellant was on bail by this honorable court. Thereafter, hearing the case with the non-appearance imbue was issued and he was arrested.
कौन पे आसिना ना कौन पे दउथले हाई कोर्ट लीगल सर्विस ଯେତେବେଳେ ନୋଟିସ ବୋର୍ଡରେ ବାହାରିଲା ଇସି କମି କଣ କହିଲେ? will remove from panel. Yes, Mr. Parija, what is there?
My lord, the client were on bail by this honorable court. After that while hearing, the case was came on a hearing list. Not for non-appeals, NBD was issued. Thereafter, they were arrested in jail post. And finally, this case,
Press bail appeal.
No bail, you argue the matter on merit. You have received the paperwork. What is the case?
Document 302, and there is eyewitness to the occurrence.
Who is the eyewitness?
3 and 4 are the eyewitness to the occurrence.
Yeah.
3 is the son, 4 is the granddaughter of the deceased man.
रखा था उसे सत्य बोला था. Read the evidence.
With only three minor. I know all the accused persons. This is Balaram is my father. On 13/9/2001, I returned to my house from my duty and took rest till 1 p.m. When I again wanted to go to my work at 1 p.m. and opened the door of my house, I found accused Juria Naik holding a kati in his hand, was shouting towards my father, and went to my father. He ensued quarrel with my father. At that time, I was asking Juria as to why he is quarreling with my father, and I saw accused Juria gave the kati blow on the head of my father. My father fell down on the ground. I immediately rushed near my father to his rescue, but accused Juria dealt a kurhadi blow on the face of my father, causing bleeding injury. When I was trying to snatch away the kati from the hand of Juria Naik, his father Kasi, holding a bhusa, came and gave the bhusa blow. As a result, I sustained injury on my head and right wrist. My villager Vijay came and interfered when the accused Juria chased him to assault. But Vijay ran away from the spot. Thereafter, Juria chased me, raising that kati while shouting to finish all the family members of Bolia. I immediately went and informed Balipadara outpost over phone, and also went to Balipadara outpost, where I was told that the police officers have already left the outpost towards the spot. I immediately returned to the place of occurrence and found the police have already arrived near the spot. On my instruction, police wrote the FIR. The contents of the FIR was read over to me, which was found correct, and I gave signature. This is the FIR marked as Exhibit 5, hyphen my signature. At the time of occurrence, my daughter Kajuni was only present, and the rest members of my family have gone to forest for wood. I was sent to hospital for medical examination. I was medically examined. The doctor obtained my signature marked as Exhibit 6. My lord, my father and we, 2 brothers, have separate mess, having 3 separate houses. The house of my brother adjoins to the house of my father, but my house is 4 houses is away from the house of my father towards south. The accused persons have their house in the same street. The house of the accused persons are 8 houses away from the house of my father in the same street. The accused persons used to go to village pond to take bath in the village road in front of our house. I informed the police over phone of Littu Patnaik of Antarpada. I now do not remember. I do not remember the phone number. I gave in writing a slip to Litu Patnaik, basing upon which he informed the police over phone. Village Antarapada and Baksipalli are two adjoining villages. The house of my father is the last houses of the street on the northern side. The house of Bidhan Naik to the south of the house of my father, and to his further south, the house of Musa Naik, and the house of Khalia Naik to further south, and the house of Sudan to further south. House of Ananta Naik is to the south of Sudam Naik, and my house is to the south of Ananta Naik. House of Santo and Bhajo Naik are to the south of my house. On the date of occurrence, I was working at Jagannath Mandir. I was working at Jagannath Mandir, being engaged by Shivapadi. The Raghunath temple is 1.5 kilometers from my house. It is not a fact. Juria has not abused my father, saying, "Achi gunia achi taku hanibi." It is not a fact. He has not quarreled with my father. I do not know if any relative of Juria has died in witchcraft. None of the villagers of our area tell my father as Gunia of that area. It is only on the date of and the time of occurrence I heard from Juria abusing my father as Gunia. It is not a fact. While Juria was going to take bath in the village tank, my father chased him to assault, alleging as to why he is abused as Gunia. Juria might have sustained injuries by his own kati in his hand, as at that time he was brandishing the kati under the influence of liquor. I have not sustained any injury by the kati in the hand of Juria. It is not a fact that Juria was not holding any kati, nor assaulted to my father, nor I have gone near him to snatch the kati from him. It is not a fact Balaram first assaulted to Juria by means of a tangia. I sustained the injury on my head and hand on the pointed iron portion of Bhusa of accused Kasina. It is not a fact that I was not assaulted by Kasia and deposed falsehood. It is not a fact that I created a case of myself. I created a case of my self-injury to pose myself as eyewitness to the occurrence. It is not a fact. I did not mention in the FIR that Vijay Karji came to the spot and separated Juria, but he was chased away by Juria. It is not a fact that there is no such occurrence of Juria assaulting to my father or chasing me to assault. It is not a fact that I deposed falsehood that Guria have the kurhadi blow to the face of my father. It is not a fact Guria snatched away the kurhadi from the hand of.
So one is PW3 is one eyewitness.
Son of the deceased.
He is son of the deceased.
Vijay examined. Vijay examined.
Vijay examined as PW1. He does not supported the case.
PW4 is another eyewitness.
The granddaughter of the deceased.
What he has stated also.
Like this, but there is some discrepancy, my lord. But he stated
came and abused JJ Bapa.
But at the time of the occurrence, he was only 5. Only 5 years.
My JJ Bapa came out
after
of the house, asked Jury as to how in the course of warning, Juria dealt Kaki blow on the backside of it. My JJ Bapa fell down on the receiving. When accused Juria came, dealt Kurhadi blow on the cheek.
And as a result, he died at the spot.
So same thing has been stated. I also stated
regarding the threatening part.
No, threatening assault part.
Assault part but my lord, at the time of occurrence, he was only 5. After 3 years, he was examined by the court.
It's all right.
No, it is not.
So these incidents will
if 5 years girl will recall everything
Guria dealt Kati blow on the head of my father. One. Number two is that Guria dealt Kati blow on the face of my father, and both the two blows have been given. And the doctor is PW6.
And the Kati was not seized.
These those things, Kati was. The PW6.
PW6 the doctor.
And like the two injuries are there. Two injuries. On the death of author due to excess marriage and so on. Time since death is 1. And he examined so the weapon of offense and state that it is possible. So excessive hemorrhage. There was some kind of war between the parties or what?
Between the appellant number 1, Juria Naik, and the deceased. See, the appellant number 1, Juria, sustained four injuries inside,
right.
Though it is simple. But the evidence of
who is the doctor?
PW.
Who is the doctor who treated that appellant Juria?
Juria PW6, so Malor PW7 examined PW3. The injured. That's
no, accused.
You are telling that accused has also sustained. Who is that accused?
Prosecution need to explain those.
Clear, but it is in the evidence of the IO that he sustained injury.
Where is that?
Well, PW9.
Who lined up?
Malor, page 71. Para 4. On the product, my lord, on the production of a police constable, I have seen the white cotton lungi, the command certificate issued to him, prepared schedule list, and the list, the MOV is the said white cotton lungi, stained with blood, which was seized on 15/9
report of accused.
I have received the injury report of the accused Juria.
Simple injuries were there.
Man,
so what is your case? Have you put up a case that have you questioned that how there were simple injuries noticed on the person of this accused? Anything brought out?
That part.
So suppose during course of the occurrence, the accused persons also sustained some injuries, but prosecution is not explaining the same.
Prosecution is not explaining.
But where is that thing that these injuries were sustained during course of the occurrence? It might have happened unless
that is Exhibit 12/2. Doctor who examined Juria on police requisition by the Exhibit 12 has mentioned in the report that Juria had 3 inside wounds situated on the right side anterior part of his head.
No, where is the material? We are asking you a question that where is the material that those injuries were sustained by the accused during course of the occurrence? If that would have been there, then if the prosecution does not offer any explanation, it might be said that they are suppressing a part of the occurrence. Okay, but if there is nothing, what is your defense plea actually?
Defense plea, private defense for Juria has sustained injuries.
313, question number 23. 313 statement is question number 23.
It is.
You want to say I am?
My wife was ill.
No, 23. I am innocent. I have never assaulted also, but copy it false case. I have
page 38 of 13 Juria. Question 23. You have had the evidence of prosecution. Do you want to say anything in support of your defense?
Yes, sir.
My answer, my wife was ill. I brought medicine and kept it in my house while I was going to take bath in the village. And on the day of occurrence, the deceased Balaram assaulted twice on my head and on my eyebrow by a kurhadi, as a result of which I sustained bleeding injuries.
Who is Guna Naik also?
Guria, my lord, he also stated the same that my brother was assaulted by
बुरा नहीं, बुरा नहीं.
well,
Two accused were there, बुरा नहीं.
You have not taken any free of right of private defense in that way.
Nothing.
And if it is not even there, but on record, except the injury report which has been proved by the IO says that on receipt of the injury report, jury anaya, 4 cm on the right side, anterior part of the head, and inside bone also. In the inside bone region. 40 date and examination. 14/9 ଦେଖନ୍ତୁ date and time of examination ହଉଛି 14/9/2001 ଦିନ ଗୋଟାଏ ବେଳେ ଆଉ ଏଜ୍ ଅଫ୍ ଇଞ୍ଜୁରି ହଉଛି 6 ରୁ 12 ଘଣ୍ଟା ବୁଝିପାରିଲେ ତେଣୁ 14/9/2001 ଗୋଟେ PM ଏଜ୍ ଅଫ୍ ଇଞ୍ଜୁରି ହଉଛି 6 to 12 hours ତାମାନେ ଯଦି 13 ତାରିଖ ଦିନ 13/9/2001 ରାତି 12ଟା ପରେ ଯଦି ଇଞ୍ଜୁରି ଗୁଡାକ ହେଇଥିବ ତାହେଲେ ଘଟଣା ଯଦି ସେତିକି ବେଳେ ହେଇଥିବ ତାହେଲେ ତାକୁ ଲିଙ୍କ କରିବ ଏ ଘଟଣା କେବେ ହେଇଛି
13/2/2001 9 by mistake ହେଇଯାଇଛି
13/9 ଟାଇମ କେତେବେଳେ
1 PM 13/9/2001 1 PM
1 PM ମାନେ କଟି ଯାଉଛି ଟାଇମ ବାହାର କରି ଯାଉଛି ଆପଣ FIR କୁ ଆସନ୍ତୁ FIR ରେ ଦଉଛି ଦିନ ଗୋଟେ ବେଳେ ଜଣ ଘଟଣା ହେଇଛି ଆଉ ଡକ୍ଟର କହୁଛନ୍ତି ଏଇ ଯୋଉ ଇଞ୍ଜୁରି ଆପଣ ରିସିଭ କରିଛନ୍ତି ଡକ୍ଟର ତ ନୁହେଁ ଯୋଉ IO ପ୍ରୁଭ କଲାନି କି ଆପଣଙ୍କର Exhibit 12/2 Exhibit 12/2 ରେ କହୁଛି
6 to 12 hours.
6 to 12 hours ଦିନ ଗୋଟେ ବେଳେ 13 ତାରିଖ ଦିନ ଏକ୍ସାମିନ ହେଲେ ଦିନ ଗୋଟେ ବେଳେ ତାମାନେ 12 ଘଣ୍ଟା ହେଲେ ବି ରାତି 13/9/2001 ରାତି 12ଟା ପରେ ଯଦି ଘଟଣା ହେଇଥାନ୍ତା ତାକୁ ଲିଙ୍କ କରିନଥା ଏଟା ବିୟଣ୍ଡ ହେଇଯାଉଛି how do you correlate with that these injuries were caused during the course of occurrence ଯଦି ତାକୁ ଲିଙ୍କ କରିପାରିବୁନି ଆମେ ତାହେଲେ how then we will say that these were caused during the course of occurrence and the prosecution should have explained whatever it may be. So that question goes. So now if that is goes, then both of you have assaulted. One has assaulted by means of a kati on the head. The other has given a kurhadi blow, that one face. And the doctor, PW, 6, no? PW6 has noticed 2 inside wounds. One is on the right ear, and the other inside wound on the occipital area in the midline. And the cause of death was due to both the injuries are on the head, due to hemorrhage leading to shock. You have used the sharp side weapon of the weapons and assaulted on the head, both of you. That is the evidence that has not been shattered because a minor contradiction ku chhadi diyantu. Major part जोटा अच्छी जे आपण दी जणे मारला कातीरे आउ जणे मारला कुराड़ी और दीटा जाक इंजुरी हेड रे हिची आउ that is the result which resulted in the death of the deceased and whatever injuries you have sustained that cannot be correlated to the time of occurrence. So that means it has been received afterwards. Time of occurrence होची दिन 12टा गोटे এই जो घटना आपण इंजुरी हला राती गोटे परे जदि हमें देखिबे तेणु लिंक करि होबनी लिंक न करले
13/9/2001 1 PM incident
occurrence
ଏଇଟା ହଉଛି 14 1 pin
24 ঘন্টা
6 ଘଣ୍ଟାରୁ 12 ଘଣ୍ଟା ଭିତରେ ହେଇଥିବ ଏଇଟା।
24 ঘন্টা
ହଁ ଏଇଟା 24 ଘଣ୍ଟା ହେଇପାରେ। ସେଇଥିପାଇଁ ରାତି 12ଟା ପରେ ଯଦି ଘଟଣା ହେଇଥାନ୍ତା ତାହେଲେ ଟୁ ସମ୍ ଏକ୍ସଟେଣ୍ଟ ବ୍ଲେମ୍ କରିବ। So this evidence has not been shattered at all. Have you brought out anything?
Regarding the evidence of PW1,
Leave those two persons. You come focus on
how
this.
to get out of the evidence of 3 and 4 and the doctor's evidence 7. How will you get over it?
On the witness hostile we are not on that. We are on the two eyewitnesses.
report.
How will you get over?
How do
3, 4 and 7.
7 is the doctor, yes. Their evidence is getting corroboration, and there is nothing that they
unless you discredit these witnesses.
My submission is that the 4 is a girl of 5 years at the time of occurrence. He adduced his evidence in the when
After 3 years.
8 years. After 3 years. If 5 years girl, my lord,
have you noticed that in the PW4 it has been mentioned that the witness is tested under section 18 of the Evidence Act, giving rational answer. So that is what required to be. So he is satisfied, the court is satisfied, and he has answered to in the cross-examination.
And for a 5-year girl, if this kind of act is done in her presence, she will never forget.
Child witness is a competent witness once he is giving rational answer. Following, so the court has observed it.
He also stated that Dr. Kujuniwaju only available.
And 3-4 only available.
The coach is second parade. At the time of occurrence, my Dr. Kujuniwaju only present at the.
But the PW4 says immediately after the occurrence, I went to the outpost to intimate the occurrence. But PW3, her daughter stated that while the appellant 1 tried to attack him, he concealed himself in the room. My lord, the C report,
Page 76.
the acts that was used, there is no opinion regarding the blood grouping.
Both the appellants are now in jail custody. The appellants, Juria Naik and Guru Naik, face trial in the court of an additional Sessions Judge Bhavjanagar in SC number 29 of 2002 for offences punishable under section 302 by 34 of the Indian Penal Code on the accusation that on 13/9/2001 at about 1 p.m. in front of the house of Balaram Naik, bracketry hereafter the deceased, at village Bakshipalli, they committed murder of the deceased in furtherance of their common intention. Stop. They were further charged under section 307 by 34 of the Indian Penal Code on the accusation that they assaulted Mishra Naik, bracketry PW3, by an axe with intention commit his murder in furtherance of their common interest. The London trial court by the into judgment and order dated 10/11/2004 though acquitted both the appellants under section 307/34 of the IPC, but found them guilty under section 302/34 of the IPC. And sentenced each of them to undergo imprisonment for life and to pay a fine of ₹1,000 in default to undergo RI for 3 months. Next para. The prosecution case, as for the first information report lodged by Vipracharana Naik, bracketed PW3, on 13/9/2001 before the officer in charge of Uguda police station, in short is that the appellants were two brothers, were always making aspersion against the deceased for practicing witchcraft. The informant on 13/9/2001, the informant, after returning from his works, was taking rest in his house and at about 1 o'clock he got up to proceed towards Raghunath temple. And at that time, both the appellants were found quarreling with the deceased and accusing him for practicing witchcraft. When PW3 intervened, appellant Juria Nair dealt a Kati blow on the head of the deceased, for which the deceased fell down on the ground. The appellant Juria Nair also dealt a Kuradi blow to the deceased on the cheek. While the deceased was lying down. The informant, bracketed PW3, snatched away the Kati from the hands of appellant Juria. However, at that time, the father of both the appellants, namely Kasia Naik, attacked the informant, bracketary PW3. And appellant Juria also chased the informant to assault him. It is further stated in the FIR that the informant came to Kalipadar outpost informant telephone to Kalipadar outpost and further stated that at the time of occurrence, his son and daughter, so also the son and daughter of his younger brother, were playing on the veranda of the house, and other family members were not present. And that the dead body of the deceased was lying in front of the house. The oral report of PW3 was reduced into writing by OIC, Buda Police Station, and Uguda PS case number 130 dated 13/9/2001 was registered under section 302, 294, 323 by 34 of the Indian Penal Code. PW9 Ashok Kumar Mahanti, the officer in charge of Buda Police Station, took up investigation of the case, he visited the spot, examined the informant and other witnesses, held inquest over the dead body, and prepared the inquest report Exhibit 1, and sent the informant, bracketary PW3, to Balipadar PSC for his medical examination on police requisition. So he seized sample earth and bloodstain earth, and also the lungi of the appellants. Exhibit 2 tower. Appellants under seizure list Exhibit 2. appellant number, appellant Guria Naik, appellant, under seizure list exhibit. He searched the house of the appellant Guria Naik in presence of the witnesses and seized one axe stained with blood under seizure list exhibit 3. And also seized the wearing apparels of the appellant Juria Naik from his house, which were stained with blood under seizure list exhibit 4. He sent the dead body for post-mortem examination. Conducted raid in the house of the appellants, but could not arrest him as they were absconding. Ultimately, the appellants were taken into judicial custody. Appellants were arrested and they were sent to the hospital for their medical examination and forwarded to the court. The IO bracket here, PW9, sees the white cotton lungi of the deceased on the production of the constable after the post-mortem of the deceased as per seizure list exhibit 11. He also received the injury report of the appellant Juria Naik. Right, exhibit 12/2. And forwarded both the appellants to court on 15/9/2001. He received the post-mortem examination report of the deceased from SD Hospital, Bhanjanagar. The Superintendent of Police supervised the case and stopped. The IO sent the asked bracket move on to the medical officer of SD Hospital, Bhanjanagar for examination, who conducted PM examination and obtained the query report. He also seized other articles and took steps to send it to Deputy Director RFSL Barampur for chemical examination through SDGM Anjanagar and received the chemical examination report by Exhibit 15. And on completion of investigation, he submitted charge sheet against 3 accused persons, including the 2 appellants, under section 294, 302 by 34 of IPC and under section 307 of IPC against the accused Kasinath Naik. The father of both the appellants, showing Kasinath as an absconder. After submission of charge sheet, the case was committed to the Court of Session, complying due procedure, where the London Trial Court framed charges against the appellants as aforesaid. Since the appellants refuted the charges, pleaded not guilty, the sessions trial procedure was resorted to establish their guilt. In order to prove its case, the prosecution examined 9 witnesses. The prosecution also proved 15 exhibits. The prosecution also proved 5 material objects. The London Trial Court, after assessing the oral as well as documentary evidence on record, came to hold that the evidence of PW3 and the evidence of the doctor makes out a case of homicidal death of the deceased. The London Trial Court assessed the evidence of PW3 and PW4, who are the eyewitnesses to the occurrence. And found that nothing has been elicited in the cross-examination so as to discredit their sworn testimony. The London Trial Court discarded the contention of the London Defense Counsel that the evidence of PW4, which is child witness, should not be accepted. It was observed that the recitals of the inquest report, also the postmortem report, corroborates the evidence of the 2 eyewitnesses, that is PW3 and PW4, regarding use of sharp cutting weapon at the time of assaulting the deceased. The Grand Trial Court further held that even if PW3 and PW4 are related to the deceased, but on that ground, their evidence cannot be discarded. Though the contention was raised that appellant Juria Naik has sustained incised wound on his person, and even if he has assaulted the deceased, he would be protected in view of his right of private defense. But the London Trial Court has not accepted such submission and held that there is no evidence on record that the deceased Balram was the aggressor and he caused the injuries on the person of appellant Juria. The London Trial Court further held that there is no evidence on record that the deceased was armed with any deadly weapon or he assaulted appellant Juria by means of such weapon. And therefore, it is difficult to believe that the appellant Juria sustained the injuries during the occurrence. The London Trial Court further held that the manner in which both the appellants attacked and assaulted the deceased, the manner in which they left the place of occurrence, and the weapon of offense used by them, when considered, the cumulative effect of the same goes to indicate that both of them have committed the murder in question in furtherance of their common intention. The London Trial Court further found that the evidence of PW5 also corroborates the evidence of PW3 and 4. It was held that the appellants had the requisite mens rea and intention and intentionally caused the death of the deceased, and both of them were armed with kati and axe. And therefore, the prosecution has proved that they, in furtherance of their common intention, caused the death of the deceased. The trial court, however, did not found any material against the appellants for the charge under section 307 by 34 of the IPC and accordingly acquitted them. However, found them guilty under section 302 by 34 of the Indian Penal Code. Mr. Vikas Chandra Parija. And counsel for the appellants argued that the two eyewitnesses are related to the deceased. PW3 is the son of the deceased, and PW4 is the granddaughter of the deceased. PW4 when deposed in court was 8 years old age, and she was a child witness, and there is every chance of tutoring such witness, and therefore the London trial court should not have placed implicit reliance on the testimonies of these two witnesses in view of their relationship with the deceased. He further argued that the investigating officer has seized the injury report of accused Julia, which has been marked as Exhibit 12/2, and it indicates that the appellant has sustained 3 incised wounds. And though the injuries have been opined to be simple in nature, but the prosecution witnesses, particularly PWs 3 and 4, have not explained as to how the appellant Julia has sustained such injuries. And therefore, the witnesses cannot be said to be truthful witnesses, and they have suppressed the genesis of the case. And in view of the London Council further argued that even though the axe was seized during course of investigation, and the doctor on examining the axe opined that the injuries on the deceased would be possible by such weapon. But in the chemical examination report, no opinion could be arrived whether the blood was of which origin and which group. And in such view of the matter, it is a fit case where benefit of doubt should be extended in favor of the appellants. Mr. Jateshwar Naik, an additional government advocate, on the other hand, supported the impugned judgment and argued that merely because the PW3 and PW4 are related witnesses, that cannot be a ground to discard their testimonies, which has been rightly done by the London trial court. Moreover, their evidence that both the appellants assaulted by sharp cutting weapon to the deceased on the vital part of the body, like head, is getting support from the medical evidence which has been adduced by the doctor, bracket PW6, was specifically opined that the death of the deceased occurred due to excess hemorrhage leading to shock. The Land Council submits that the child witness has been tested by the court and found to be giving rational answers, and nothing has been brought out to show that she has been tutored to depose falsehood against the appellants. The Land Council further submits that the evidence of the doctor also indicates that the weapon that was seized from the house of the appellant was produced before him, and he verified the same and opined that the injuries on the person of the deceased would be possible by such weapon. He further submits that PW5 who is the brother of the informant and arrived at the spot after coming to know about the occurrence, was told by PW4 Hojini Nair that both the appellants assaulted the deceased. And therefore, the evidence of the eyewitnesses is not only getting corroboration from the medical evidence, but also from the evidence of PW5. It is further argued by the Land Council for the state that even though the IO has proved the injury report of appellant Juria Naik via exhibit 12/2, but the medical examination report indicates the date and time of examination is 14/9/2001 at 1 p.m. and the age of injuries was 6 to 12 hours. And since the occurrence in question took place on 13/9/2001 at about 1 p.m., therefore, these injuries sustained by the appellant Juria Naik cannot be correlated to the time of occurrence, and therefore, if the appellant number 1 has sustained such injuries afterwards, there was no need on the part of the prosecution to explain such injuries. The Land Council further argued that in view of the part of the body on which both the appellants assaulted by sharp cutting weapon and the type of injuries sustained by the deceased and the cause of death as has been opined by the doctor PW6, it can be said that both the appellants in furtherance of their common intention caused the death of the deceased by assaulting him, and therefore there is nothing to be interfered in the criminal appeal and it should be dismissed. adverting to the contention raised by the land council for the respective parties, before going to deal with the other aspects of the case, let us first examine how far the prosecution has successfully established that the deceased died a homicidal death. Apart from the inquest report, bracket ray, Exhibit 1, prepared by the investigating officer, the evidence of the medical officer, PW6, is very relevant on this issue. PW6 was attached to SD Hospital Manja, Nagar, and he conducted postmortem examination over the dead body of the deceased on 13/9/2001, and he found the following injuries. He has opined the cause of death as so and so, time of death so and so. He proved the PM report Exhibit 7. He has further stated that the IO produced the weapon of offense before him on 22/11/2001, and he examined the same with reference to the PM report and submitted that the wounds mentioned in the PM report could be caused by the sharp edge of the iron part of the axe, and his report has been marked as Exhibit 8. Nothing has been brought out in the cross-examination to discard or disbelieve the evidence of the doctor. In fact, the Land Council for the appellant has also not challenged the evidence of the doctor. In view of the inquest report, the evidence of the medical officer PW6, and the postmortem report Exhibit 7, we are of the view that the London trial court has rightly come to the conclusion that the prosecution has proved the death of the deceased to be homicidal one. Next para. The case of the prosecution now mainly is based on the evidence of the two eyewitnesses to the occurrence were examined as PW3 and PW4. PW3, Vipro Nayak, is the son of the deceased, and he has stated that on 13/9/2001, after he returned to his house from duty and took rest till 1 p.m. and wanted to go to the work at 1 p.m. and open the door, he found the appellant Julia Nayak was holding a kathi in his hand and shouting towards the deceased, and ensued a quarrel with the deceased. He further stated that when he asked the appellant Julia as to why he is quarreling with the deceased, the appellant Julia dealt a kathi blow on the head of the deceased, for which the deceased fell down on the ground. He further stated that when he rushed to his father, bracketed deceased, to his rescue, appellant Guria dealt kurhadi blow, axe blow like this, on the face of the deceased, causing bleeding. He further stated that he tried to snatch away the kathi from the hands of accused, appellant Julia Nayak. But at that time, the father of both the appellants came there holding a bhusa and gave him busa blows, as a result of which he sustained injury on the head and right wrist. He further stated that appellant Juria also chased him to assault, chased when one Vijay bracket PW1 came there and interfered, the appellant Juria chased him to assault, but PW1 ran away. The appellant Juria then shouted that he would finish all the family members of the deceased. He further stated that he immediately informed Balipadar outpost over phone and went to Balipadar outpost, where he was told that the police officers have already left to the place of occurrence. And he immediately returned to the spot and found that the police had already arrived. And on his oral version, the police wrote the FIR and it was presented. In the cross-examination, he has stated that the houses of the appellants are 8 houses away from the house of the deceased in the same street. He further stated that he has not sustained any injury by Kati in the hands of Juria. Some suggestions have been given to PW3 that it was the deceased who first assaulted appellant Juria by means of a tangia, for which he sustained head and hand injuries. But he has denied such suggestion. Nothing has been brought out further in the cross-examination to disbelieve the evidence of PW3. So far as PW4 is concerned, though he is a child witness, but he has been tested by the London Trial Court. And it was found that she was giving rational answers. In view of section 118 of the Evidence Act, a child witness is a competent witness however, greater scrutiny and close circumspection is required while assessing the evidence, assessing his oblique her evidence. When the child is matured and understands the question and answers in a position to understand the false statement and applying the test of practical wisdom, evidence of such child cannot be discarded. Of course, there is no quarrel over the proposition that the child witness are easily susceptible to tutoring and to telling imaginative stories, and therefore it is required that the evidence has to be scrutinized with extreme care and caution before being acted upon as true and dependable. In the case in hand, the London Trial Court has put some questions to the witnesses and found that she is giving rational answers. And thereafter he has recorded the evidence of PW 5. In our evidence, PW 5 has stated that the appellant abused, appellant Julia Naik abused the deceased and dealt a kati blow on the backside of the head, for which the deceased fell down, receiving the head injury, and then accused Julia Naik dealt an axe blow on the cheek of the deceased, as a result of which the deceased died at the spot. He further stated that at that time, the father of both the appellants, Tasia, came there and assaulted to PW3. But out of fear, PW3 ran away, and thereafter the appellants left the place of offense. It has been confronted to PW5 and truth to the IO bracket ray PW9 that she did not specifically stated sorry PW4 the category. Those the some of the previous statement of the witness has been confronted to her by the London Defense Council, but it has not been proved to the IO. The witness has categorically stated that there was no tussle took place between the appellant Juria and the deceased. She denied the suggestion given by the London Council for the Defense that out of fear she entered inside the house at the time of assault. Nothing further has been elicited in the cross-examination of PW4. Even though they are related to the deceased, but law is well settled that related witness is not necessarily interested witnesses. Rather, they are the last person to spare the real assailant and implicate someone falsely. We find that both the eyewitnesses, that is PW3 and 4, are truthful witnesses, and their evidence that both the appellants assaulted by means of sharp cutting weapon is getting ample corroboration from the evidence of the doctor bracket ray PW6 who conducted post-mortem examination. Moreover, the prosecution is not disputing the presence of, defense is not disputing the presence of right. Moreover, the evidence of PW3 specifically indicates that he sustained injury on his head and hand on the pointed iron portion of Gusa, which was used by the father of the appellants. And the doctor, PW7, has examined him and noticed some injuries on his person. Therefore, as an injured witness, his presence at the scene of occurrence cannot be disputed. Coming to the injury report of appellant Juria Naik, we found, as has been rightly pointed out by the London Council for the state, that the date and time of examination of appellant Juria was 14/9/2001 at 1 p.m. And though some incised wounds were noticed on the person of juria, but the age of injury has been opined to be 6 to 12 hours. Since the occurrence in question took place on 13/9/2001 at about 1 p.m. Therefore, the injuries which have been sustained by the appellant Juria Naik cannot be correlated to the time of occurrence. And therefore, we are of the opinion that the prosecution is not bound to offer the explanation regarding the injuries of the appellant Juria. In view of the foregoing discussions, we find that not only the prosecution has proved that the deceased died of homicidal death, but the evidence of the two eyewitnesses to the occurrence, which has not been shaken, has given a clear picture that it was the two appellants who were the assailants of the deceased, and it was on account of their assault that the death of the deceased took place. Since the injuries were caused on the right part of the body like head, and the cause of death was also due to hemorrhage and shock, as opined by the Dr. PW6, and both the appellants participated in the assault of the deceased. Therefore, can be said that in furtherance of their common intention, they have committed the murder of the deceased, Balaram Rai, and therefore the London Trial Court has found them guilty, rightly found them guilty under section 302(y)34 of the Indian Penal Code. Accordingly, the jail criminal appeal being favored of merit stands dismissed.
Item 5. Appointment of the Rahul item 5 in the report.
Yes.
Got any information?
So,
Where is that document? You are Madam Milan Behra.
Yes, ma'am.
So have you not gone through the cause list today? You are not having the cause list. Now the cause list are uploaded in the High Court website. So when you are been interested with some matters in criminal appeal or other matters, you should see the cause list regularly. That is the main duty of a counsel. How can you know otherwise? You may miss the case and the case would be dismissed and your client would suffer. And this is a jail criminal appeal. He has been sentenced to life imprisonment.
Are you a regular practitioner of this court or trial court?
Trial court.
How many years of practice you have?
Mainly 10 years.
Huh?
10 years.
10 years. You have given your name to the Secretary of the High Court Bar Association. That is how your name came to us, and it was in that panel. It was your name is added, and I am told by that before giving your name, you have been asked that whether you are interested to be appointed as counsel or not. You gave your consent, and accordingly you have gave your consent. You have been appointed.
I'm interested in this.
It's all right, madam. You are interested. You gave your name. We also accepted as the advocate of the, but you are not appearing. And do you know that this man is in custody since he was taken into custody in 1998? So he has remained in custody how many years?
28 years.
So in such matters, if the counsel is having no money to engage a counsel, that is why the jail criminal appeal has been filed. And he will not appear.
You should have moved some memo and all. This is on our effort, it listed. You have not made any efforts.
Sorry.
Take down the Mishra Land Council for the Land Council who has been engaged by us by the order dated 30/10/2025 is present. The Land Council for the state has produced the report of the Superintendent Special Jail Rourkela, which shows that the appellant Lokudas has been released prematurely as per the order of the government dated 26/5/2017. The relevant document is taken on record. The jail criminal appeal is disposed of.
And if you do this exercise, we need not ask for personal appearance. This exercise has to be done by you when the matter is taken up.
Yes, so now on to the next one. Item number 7.
Item 7.
That's the superintendent of the jail.
Madam, apna na kuhନ୍ତୁ
Swagatika Das. Sir, my name is Swagatika Das.
ଆପଣ
Region
କଣ
Welfare
ଅଛନ୍ତି?
Officer. Region Welfare Officer. Special Jail Rourkela.
Officer ଅଛନ୍ତି?
Who officer?
Region Welfare Officer.
In welfare.
ନା 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 କଣ କହିଲି ସ୍ୱାଗତିକା ନା
What Sagatika? What is the name?
Swagatika Das.
Prison Welfare Officer
Special Jail Rourkela.
Special Jail Rourkela is present through virtual mode and ତାପରେ ଏଇଟା ଲେଖିଦଉ ହେଲା ଠିକ ଅଛି ମ୍ୟାଡାମ thank you. Then item number 7 ରେ କଣ ହେଲା କୁହନ୍ତୁ ଏଟାରେ ପେପର ବୁକ୍ ହେଇଯାଇଛି
Good night, it is 3:02.
So this man, as it appears, he was gone on a furlough leave for a period of 14 days in 2009 to attend his ailing mother, and his father stood as a surety for him. But thereafter, he has not surrendered and found absconding. And letters have been sent by the senior superintendent Circle Jail Cutter Chaudhar to the OIC of Rajnagar Police Station to recapture the appellant. So we have, of course, stated that the London trial court shall intimate us about this, but you are to take instruction.
Yes, flag wise.
Flag wise on further verification. 14 days instructions to the recapture. Send in search. ଆପଣ ଏଟା instruction ନିଅନ୍ତୁ officer in charge of Rajnagar police station, maybe ବର୍ତ୍ତମାନ IAC ହେଇଥିବ he has to visit the house of the appellant and ascertain his well-being, his availability, whether he is alive or not, and submit a report to that effect. 2009 ମସିହାରୁ abscond କରିଛି 14 ଦିନ ପାଇଁ ଯାଇଥିଲା ମାର ଦେହ ଖରାପ ଗ୍ରାମରେ ବାପା ଛିଡା ହେଇଥିଲା ସିକ୍ୟୁରିଟି ହିସାବରେ ତାପରେ ଆଉ ଫେରିନି. And what about Reena madam? Reena Nayak? She was interested. He was engaged in 2007. ଜାଣିଛନ୍ତି ନା ନାଇଁ ପଚାରି ଦିଅନ୍ତୁ ଯଦି ନ କରିବେ ଆମେ ଅନ୍ୟ କାଉନସିଲକୁ ଏନଗେଜ କରିଦେବୁ ହେଲା ଦେଖନ୍ତୁ in view of the have you obtained any instruction? No, madam. ଆପଣଙ୍କୁ ଗୋଟେ କପିଟା କଣ ପାଇଁ ଦିଆ ହଉଥିଲା ଆପଣଙ୍କୁ ଫ୍ରି କପି ଦିଆହେଲା ସେ ଲୋକଟା 14 ଦିନ ପାଇଁ ଯାଇ ଆଉ ଆବସେଣ୍ଟ କରିଯାଇଛି ରାଜନଗର ପୋଲିସ ଷ୍ଟେସନ ରେ ତାର ଘର ଆଣିବା ପାଇଁ jail authority submitted report that jail authority submitted a report that they have found କଣ jail report of the jail authority ହଁ jail authority କହିଲେ ପରା ପଳେଇଛି ଆରେ ତାପରେ କଣ ହେଲା ସେ ଲୋକ 2000 ଆପଣ ଦେଖୁଛନ୍ତି ତ ସେ ଅର୍ଡରଟା ହେଇଛି 2009 ରୁ ମାନେ 16 ବର୍ଷ ହେଇଗଲାଣି ଅଫିସର ଇନ ଚାର୍ଜ ରାଜନଗର ପୋଲିସ ଷ୍ଟେସନ କୁ କୁହନ୍ତୁ ଆଉ ସୁପରିଟେଣ୍ଡେଣ୍ଟ ଅଫ ପୋଲିସ କେନ୍ଦ୍ରାପଡା କୁହନ୍ତୁ appear କରିବେ virtually on Friday and they have to say that why this appellant has not been apprehended right listen in view of the order dated 16/4/2025 since no instruction has been received let the Land and Council for the state pass necessary instruction to the officer in charge of Rajnagar Police Station, Kendrapada. So also the Superintendent of Police, Kendrapada, to appear through virtual mode and apprise this court as to what steps have been taken to arrest oblique recapture the appellant Ravindra Kumar Koro son of Atula Koro village Ananta Kesari PS Rajnagar district cutter who was granted special furlough leave for a period of 14 days from 17/12/2009 to 30/12/2009 to attend his ailing mother and his father was stood as a surety for him and thereafter he has not returned. He has not surrendered and absconded. Matter will be taken up at 2 p.m. A free copy of this order, so also the order dated 16/4/2025 be handed over to the Land Council of the state. What happened?
medicine center
लिखिदिथा non appears for the appellant खाली कर देता କହିଦେବେ ପହର ଦିନ matter ଆସିବ ଦିଟା ବେଳେ so we'll take up this matter on 14/11/2025 at 2 p.m. Yes, next.
Item 8. Yes, my lord, I am unable to file bail bond, bail petition and VNAMA because the accused person is not interested to file any bail petition before this. So, my lord, my lord, he
Not
has
interested to
file bail petition, my lord. File bail petition.
How do you know?
Yes, my lord, he has instructed me. I am connected with telephonical call. Telephonical call, he called me and told me that he has nobody else to take him on bail. So he has filed another prison petition yesterday, my lord. But that is not coming in this.
The request has been made in December 2024 to engage you as the counsel.
Yes.
And accordingly, you have been engaged.
Yes.
Suppose the
My lord, any other
accused is not interested to go on bail, whether the appeal has to be decided on
yes,
merit
yes,
or
my lord, he put give me permission to argue this case, then I will argue this case.
But permission you
have been
engaged.
My lord,
But
VNAMA, I am unable to file
leave
VNAMA.
it. We
Yes.
have appointed
Yes,
you.
Yes, my lord.
Now you are to collect the paper book,
Yes.
prepare the case and argue.
Yes, my lord.
So what permission you require from
My
us?
lord, 2 days time may kindly be given. I will add to this case.
No. Have you received the paper book?
Yes,
copy?
I have
We
already
present the
received.
case. Lekhondu, Mrs. Vidulata Mohanty, Land Council, submits that he has received the paper book and she will argue the case next week. She further stated that on 24/10/2025, though she has made a submission before this court to obtain wakalatnama of the appellant and file the same, so also an application for bail. She submits that she talked with the appellant who is not interested to file any application for bail. What about the wakalatnama?
No, nothing has been received by me, but he has telephonically informed me that I am a poor person. I have got no money. So
wakalatnama रे money कौन देता? वकालत କୋଉ ଜେଲରେ ସେ ଅଛି?
Huntuni.
ଏଟା କଣ ଲେଖା ହେଇଛି ଆଠଗଡ଼ ବୋଲି?
ମଡେଲ
ଜେଲ ଅଛି ଆପଣ କଲେକ୍ଟ କରି ଆଣନ୍ତୁ. Reporter ଦଉଛି since the prisoner's petition indicates that the appellant is lodged in model convict prison in model कौन सेटा?
model convict jail
model convict prison, Athagod special jail. Let the London Council for the State collect wakalatnama in the meantime, so that it can be filed by the London Council for the appellant. Now hand over karibe, se aniki file karibe. And matter will come on. We are adding this matter to 26/11/2025. Sorry, next week it will 19. 19 तारीख ଆମେ add କରୁଛୁ ହେଲା. You are ଆଜି ହେଉଛି 12 ତାରିଖ. You are getting 1 week time. You prepare the case. Yes, next.
Item 9.
Your Lordship, I would like to seek an adjournment on behalf of Mr. Roman.
What for? Why?
Your Lordship, we are suffering from fever.
Mr. Patnaik was present on 7/11/2025 when took up the matter, and it's a jail criminal appeal, and he said that the appellant was taken into custody in 2011. 14 years have already passed.
custody certificate
Huh?
custody certificate custody certificate
ଦିଅନ୍ତୁ ସେ ଅଛି ତ କଷ୍ଟଡିରେ ଦିଅନ୍ତୁ. So we are adjourning it to next week. Get ready. Ask Mr. Patnaik. What is your name?
Satyavrata Mahapat.
Satyavrata Mahapat. You are an associate of Mr. Patnaik. An associate of Ramanikant Patnaik submits that his senior is not well and the matter may be taken up next week. And counsel for the state has produced the custody certificate of the appellant, which is taken on the phone. Is this matter? Say yes to say any statement. Yes.
Item 10.
On behalf of Mr. Satyanarayan Jinna,
we have not sit here to give adjournments in jail criminal appeals.
14 years he is already there in case.
He was also not present on 17/9/2025. You see, if you are not interested, you should say there are number of advocates who can do the case. You are not doing any charity.
Next week, next week.
Have you received the paper book?
Madam.
Huh?
Madam, paper will receive.
Neither you are filing any bail application, nor you are coming ready to argue the matter and seeking for an adjournment. Huh?
IA is there.
Huh?
IA is there. IA is there, man.
What offense he has been found guilty? 364-302. Well, I tell you, senior, that we'll granting till next week, but will not adjourn the matter further. Give your name. Want so the associate of Mr. Jena seeks for an adjournment till next week. Put up this matter on such and such date. 19/11/2025. Yes, next.
Item 11.
Yeah.
It's appellant has been convicted for the offense under section 307-376 your lordship and custody since 10th November 2013. And conviction is mainly based on dying declaration of the victim, your lordship, which was recorded by magistrate who has been examined as PW 22. Last occasion, lordship is directed to query about the sarpanch. At the time of recording of dying declaration,
Period 2 is the informant.
Huh?
Period 2 is the informant.
Have you seen our last order?
Last order just minor.
What is there?
Period 3 is the ward member minor.
No, dying declaration should have the evidence, right?
No.
Dying declaration is that's exhibit 1.
Minor.
Exhibit 1 re dying declaration se kohuchi je repo majiro puo has committed rape on her.
Minor.
He has not named this man. The man's
his
name
father's
is
name is
Govindra Hembram, whose father's name is Repo alias Biram Hembram. He is telling about some Repo Maji. So how do you correlate the appellant with the occurrence in question? So that is the reason why we asked you to verify if there are any other materials on record so that the identity of the petitioner can be otherwise be disclosed from. Hmm?
Have you read it or just
minor.
read it? We'll record your statement accused.
Minor.
We'll record your statement and
you have gone through the evidence. There is no material except that that Repo Majiro Puo, that is exhibit 1. Also the exhibit 1. ଆପଣଙ୍କର ନାମ କୁହନ୍ତୁ ମୋ ନାମ ସ୍ୱାମୀଙ୍କ ନାଁ କୁହନ୍ତୁ ଶୁଣନ୍ତୁ ବୟସ ଅଛି ଶୁଣନ୍ତୁ ଠିକଣା ଶୁଣନ୍ତୁ ଆପଣଙ୍କୁ କେବେ ଶୁଣନ୍ତୁ ଗତ ମଙ୍ଗଳବାର ସନ୍ଧ୍ୟାବେଳେ କେଉଁମାନେ ଆପଣଙ୍କୁ କହନ୍ତି ଜଣେ ଲୋକ ଚୈତ୍ର 72 କଲା ଆପଣ ତାଙ୍କୁ ଚିହ୍ନିଛନ୍ତି କି? ହଁ ଚିହ୍ନିଛି। ତାଙ୍କର ନାଁ କଣ? କାହାର ପୁଅ? Respective parties with period of detention of the petitioner in judicial custody and the nature of evidence available from the judge and absence of any chance of early hearing, we are inclined to release the petitioner on bail allowed. This should be communicated to the so and so. Yes, next case.
Item 12.
Madam, in this case, my lord, it is challenge the order dated 17/12/2021 as by the
You have filed a bail application for appellant number 2.
Yes, my lord.
Criminal antecedents.
No criminal antecedent.
So supposed to give the certificate.
Yes, sir.
Custody certificate. Criminal.
My lord, what?
June.
Conduct during imprisonment, property and
Music, really. କଷ୍ଟଡି କେତେ ଦେଖଉଛି? 10 ବର୍ଷ।
10 ବର୍ଷ 5 ମାସ ମାନେ।
ଆଚ୍ଛା, ଆଉ ବାହାରକୁ ଯୋଉ ଯାଇଥିଲା
ଇନ୍ ଟାଇମରେ ଆଜ୍ଞା ସସରା ନେଇ କରୁଛି।
including remission 10 years 8 months and 28 days.
ଜେଲ କଣ୍ଡକ୍ଟ ବି ଠିକ ଅଛି।
3 জন রিলিজ হয়েছেন বেললে। In this case, 4 persons are convicted, 3 already released on bail.
No, this application is for appellant number 2.
Yes, my lord.
Rajani Parida, puota na jiyota?
No, no, Ranjan Parida.
Ranjan Parida.
Ranjan Parida.
Ranjan Parida.
All other accused persons granted bail.
Yes, my lord. First is one religion bail in juvenile. During juvenile, he is
No, এই যে appellant ଆପଣ ଫାଇଲ କରିଛନ୍ତି ବର୍ତ୍ତମାନ
Ranjan Parida, my lord.
IN number 227 of 2025.
Yes, my lord.
এটা ফাইল କରିଛନ୍ତି କାହା ପାଇଁ? appellant number
2 ପାଇଁ ରଞ୍ଜନ ପରିଡ଼ା।
ଦେଖି
Arnab Ramchandra Parida.
ଆପଣ ଯୋଉ ଆଇଏଟା ଲେଖିଲେନି ତା ନାଁଟା appellant number 2 ରଞ୍ଜନ ପରିଡ଼ା ବୋଲି କୋଉଠି ଜାଣିଲେ? ସେ ତ ପ୍ରିଜନର୍ସ ପିଟିସନ ରେ ଦେଇଛନ୍ତି appellant number 1 ହଉଛି ରାମଚନ୍ଦ୍ର ପରିଡ଼ା, appellant number 2 ହଉଛି ରଜନୀ ପରିଡ଼ା, appellant number 3 ହଉଛି ରଞ୍ଜନ ପରିଡ଼ା।
Ranjan Parida, my lord, in paper book, my lord. In paper book, Ranjan Parida is 2, my lord.
पेपर बुटा नहीं वही अच्छा ठीक है रोम पेपर बुटा मार दो। अच्छा देखो देखो this IN number 227 of 2025, this is an application for bail filed by appellant number 2 Ranjan Parida. No, the learned counsel for the state has produced the custody certificate of the petitioner, which shows that including the period of on remission, the petitioner has remained in custody for 10 years, 8 months of the senior superintendent Sarkurial Fatak at Chaudhar. He has also produced the report of IIC Pandarpur police station to show that during interim bail period, the conduct of the appellant was good. He has also produced another certificate issued by senior superintendent, which indicates that the conduct of the petitioner inside jail was satisfactory, and he has shown discipline, obedience towards jail rules, willingness to work, and participation in the vocational programs. The relevant documents filed by the Land Council for the state is taken on record. In view of the period of detention of the petitioner in judicial custody, since the petitioner has not misutilized the liberty while on interim bail, and there is no chance of early hearing, we are inclined to release the appellant number 2, Ranjan Parida, on bail allowed. Two other co-convicts and the fact that the 2 co-convicts have already been released, have already been granted bail by the court. Yes, next.
Item 13.
Convicted under section 302 complains to under the life. I have filed a IS of bail. Custody since 18/1/2016. 9 years.
Yes, copy IR copy please give a copy, IR number 322 of 2025. And you have received the deposition copies. Yes, ma'am. Let a copy of the interim application be served on the Land Council for the state, who shall obtain the custody certificate, criminal instruction about the criminal antecedent, if any, and his jail conduct. How who jail ଅଛି? Bhanjanagar jail. So we'll take up this matter on 24th, 24 तारीख रखू 24/11/2025 ଆସିବ. Next.
Item 14.
May I please your lordship? The petitioner has been convicted under section 302 and sentenced to undergo RI for life, my lord, and is in custody since 1/2/2018. Is for more than 18.
Have you received the deposition copy? Deposition. Upon ye anichanti paper book achi na. So what is the offense here?
302-201, man.
Sean killed his father.
Eyewitness achandi?
No, my lords. Based on circumstantial evidence.
Or see ko din achandi upon ko din nai. Kuta satto. Mr. Ram, who is the eyewitness according to you?
No, there is no way. Sorry, my lord. Sorry.
Acha, eyewitness ଯଦି ନାହାନ୍ତି circumstantial evidence ରେ କଣ ଅଛି?
For the informant man.
ନାଇଁ eyewitness ତ ନାହାନ୍ତି, କୋଉ circumstance base କରି conviction ହେଇଛି? Judgment ରେ କୋଉ paragraph ରେ deal ହେଇଛି?
Page 32.
32 ମାନେ paragraph କଣ? Paper book ରେ 32 କହୁଛି?
ଆଜ୍ଞା, paper book. Paragraph 38, man.
38, my lord.
32, paragraph number
38.
38, my lord.
On closer scrutiny of the evidence on record, as discussed above, I found the prosecution is able to prove the following circumstances. Accused Navidetya was the son of the deceased, and prior to the occurrence, he was quarreling with the deceased. And the second one is, on the day of occurrence, the accused and the deceased were living together in their dwelling house where the occurrence took place. 3 is that after 28 days of occurrence, the dead body of the deceased was found inside the house under the earth. 4th is the deceased suffered from homicidal death. The fifth one is, on the basis of the disclosure statement of the accused, Navidetya, while in police custody, it proved that he has committed murder of his father, and to screen himself from the commission of murder, he buried the dead body inside the house. Again.
January 2026. Yes, next.
Item 15.
Yes, Mr. Das.
My lord, in this case, the prisoner has been convicted under section
Stay relation of finance डालो कर दो. Stay fine दो कर. Yes.
The prisoner has been convicted under section 302 and 201 of IPC. There is no eyewitness. Only circumstantial evidence, that is the last in case theory and dying declaration and leading to this.
Dying declaration कितना number?
Dying declaration
written ना oral?
Oral.
कहाँ पकड़े?
Informant and his brother and her brother and one.
साक्षी की. Informant कितने number साक्षी?
9.
9. कौन पढ़ लगा?
Page 91.
Paper book. Accused came to our house, took my father. Last scene.
Yes.
Father did not return. Accused also did not return. Then father was lying dead. I found as a dead man. My father was lying by the side of the oil factory with bleeding injuries, deep injury on the head, so on so on. Asked my father regarding cause of injury. My father disclosed that accused Mongula, assaulted him by means of an iron rod. For these injuries on my body, my father also told that accused told him, Kamo Koribu ki so thereafter accused assaulted him by means of an iron rod. My father also disclosed before me that Aji shouted the accused assaulted him in the left side face. So, who is the doctor?
That is the PW 39. Yes.
No, PW 13. No.
39.
39.
39.
39. Autopsy over the dead body. Injury.
Many injuries. 11 injuries.
So how do you get over the dying declaration is there?
Dying declaration is there. 4 witnesses have given dying declaration. They are contradictory to each other.
How ye कितने दिन रही होंगे?
5 years.
5 years. How? January January 22. Yes, next.
Item 16.
May I please the lordship, madam? Last occasion, CC and CA and found the called for madam.
Other time. Next week, Wednesday, State Council takes some more time to produce the documents as mentioned in the order dated 17/9/2024. 19/11/2025. Yes, next.
Item 17.
Item 17, on behalf of Mr. Panda, it may be taken up some other day.
Next week, 19/11. Give your name. Pray for an adjournment on behalf of Mr. Devasis Panda. So it is 19/11/25. Yes.
Item 18.
I filed the IA for bail under section 394 and 302 of IPC. And the custody since 29/11/2017.
17.
17, 17.
18 वर्ष जी.
Yes, yes.
Material कौन अच्छी?
The eyewitness is there, PW 9.
कौन को चीज़ है?
Right. May I? The informant Mananag. The informant Mananag is my co-villager. I know the accused standing in the dock named Shukramundar, the deceased Ramachandra Naik, who was the father of the infant. The occurrence took place about 7 years back when Ramachandra died. The accused has come from his village, Chasbasa, to our village to the house of the informant. Thereafter, the accused came to my house and stayed overnight. On the next morning, the accused called the deceased to go with him to the jungle for hunting wild boar. Thereafter, myself, the deceased, and the accused together went to the Lakshmi Mara jungle. Thereafter, both the accused and the deceased asked me to go back. As I was going back, the deceased shouted and called me back, and I went back and saw that the accused was chasing the deceased and was assaulting him with the butt of the gun, which belonged to the deceased. The accused saw me at a distance and threatened me, किसी को छोड़ेंगे नहीं. Thereafter, I came back to my house, and out of fear, I did not disclose the matter to anybody. Ramchandra were missing for 3 days and did not return back, and thereafter his dead body was recovered from Lakshmi Mara jungle. Thereafter, the police came and investigated the case as I have explained by the IO in this case.
So, how many blows you have given?
Doctor?
The doctor is 3,14.
On tar अच्छी background, criminal antecedent, jail conduct.
That report has not.
May I say? IN number so and so stay realization of fine allowed. তারপরে IN number so and so application for bail. Plan counsel for the state seek some time to produce the custody certificate. 1, 2 হচ্ছে about his criminal antecedent, and third হচ্ছে jail conduct.
Jail.
So 24 তারিখে আছে 24/11/2025. बाकी सब तो